Morning, it is 9 o'clock. We will call to order the May 6th Planning Commission meeting. First order of business is decision summary approval for our April 1st meeting. Any comments or questions on page 1, page 2, page 3, page 4, page 5, page 6, or page 7?
Move to approve as presented.
Second.
We have a motion by Commissioner Council, second by Commissioner Stranahan. If there's no further comment, we'll call for the vote. Commissioner Hikas?
Aye.
Commissioner Stranahan?
Aye.
Commissioner Council?
Aye.
Commissioner Spies?
Aye.
I vote aye as well.
All right.
Moving on to
Recuse myself now.
old business. Applicant is Dobson Lawn and Landscape Incorporated. Agent is Zach Smith.
I would like to request that we go into closed session before we get
I'll second that.
moving on this. I have a question for our attorney.
Okay, we have a motion by Commissioner Council, second by Commissioner Stranahan to go into closed session. We'll
To seek legal advice.
seek legal advice.
Yep.
Do we need to call for a vote?
I think we
We're going to call for a vote. Commissioner Council?
do. Aye.
Commissioner Stranahan?
Aye.
Commissioner Spies?
Aye.
I vote aye as well. We will reconvene shortly.
I'd like to offer a motion that we go back into open session.
Second.
We have a motion from Commissioner Council and a second by Commissioner Stranahan to go back into session after seeking legal counsel. No further comment. We'll call for the vote. Commissioner Spies?
Aye.
Commissioner Council?
Aye.
Commissioner Stranahan?
Aye.
I vote aye as well. Do we need a staff report here, or Mr. Smith, you ready to go?
We don't have any new information. We have one new public comment.
Great, thank you.
So the public comment, did we receive that, or is that the one we got last night?
Yes.
Got it, okay.
Good morning, gentlemen. Zach Smith and Timmy Dobson on behalf of Dobson Lawn and Landscaping and Timmy with his site plan application for a cottage industry. And you'll recall we were before you back in December with this application. At that time, we went through the proposed site plan, all the requirements in the county code relevant to this use, you know, which is a landscape contractor, property maintenance contractor, similar to other cottage industries the planning commission has approved. I think in December, or this 2024, you approved the cottage industry for Thompson. I think, you know, Timmy's operation is very similar to that, consistent with that. And so we walked through that site plan at that time, and I think consistent with the staff report, the staff was satisfied that the site plan met the requirements. And I think the planning commission acknowledged generally that the site plan was before you met the requirements. But there was some concern about Timmy's past operations. And, you know, we acknowledged at that time that in the past, he's exceeded what's allowable under the cottage industry. And I did report at that time that I had a conversation with Timmy. I explained to him that he basically had two choices. You know, he could look for a commercial site and maintain a larger footprint and actually grow if he wanted to, or he could scale back and fit within what's allowable under a cottage industry, under the county code, which is a use that's permitted by right so long as you fit within that envelope of what's allowed. And Timmy was very clear that he wanted to fit within that cottage industry, and really for two reasons. One, I mean, frankly, he doesn't believe he could afford to go out and buy or rent a commercial space. He would have to scale up significantly in order to do that. He invested in this property both to be his home for him and his family, but also as a base of operations for his business. And, you know, frankly, it fits very well because, as we discussed back in December, you know, this property was improved and used by Chuck Livingston for a cottage industry for several decades. It has an office, it has a shop, it has a yard, so it lends itself to Timmy's operation. And I think the other reason Timmy was interested in scaling back and not ramping up is that, you know, he's reached a point in his life where he's not necessarily trying to get every job and trying to work every hour of every day. I think he's done that. You know, he's been at this for 3 decades. And I think he's just reached a point where that's no longer appealing to him. And so the idea of, you know, just focusing on property maintenance and his established customer base is appealing to him. And that, along with the wholesale nursery operation that he's begun, you know, seems to provide everything that he needs. So before we got to the Planning Commission in December, he had started to make a move to scale back. And I had reported in December that he was under contract to sell a portion of his business. But at that time, we really couldn't give the Planning Commission the details, and it hadn't closed because it was, you know, there was confidentiality and sensitive information. And so the Planning Commission graciously allowed us to, you know, continue that review and to come back to you. We had said in March originally. And then we've been here since then, but haven't been able to get the full commission. So now we're to a point where I can report that that deal has gone through, that contract has closed, and Timmy in early January sold a portion of his business to Bartlett Tree, which included his tree division. So all of his tree contracts were sold. Fortunately, Bartlett took on the 6 employees that Timmy had that were working in that aspect of his business. They took some of his equipment, not all of it. So Timmy's to the point where he no longer does any tree work. He gladly reported that to Bartlett, and, you know, whatever tree equipment he had that he didn't sell, including some additional trucks, he has either sold or is working to sell. And so now we do feel like Timmy does fit within what's allowable, and we're back before the commission. We have some information we want to provide. We wanted to report on that sale. And actually, the additional 2 months has given us a chance to collect some additional data, which I think all demonstrates compliance. Can I pass this out?
Yeah, please.
Thank you.
Thank you.
Thank you.
So, the information here, the first item would be the employees. You know, recall under the circumstances, Timmy's allowed to have 7 non-resident employees. He actually has 5 non-resident employees. They're listed there at the top. And these are the folks that actually report to his property on a daily basis, or at least during weekdays. He also had, and then I should say, both Timmy and his son, who both live on the property, also obviously report to the site, but they're not included under the county code. I also wanted to point out that, and I know this was something Mr. Shannon asked about last meeting, you know, those apartments that exist, none of Timmy's employees live in those apartments, so they're not employees at all. And then Timmy does have some additional employees that are listed there in that second heading. These are folks that don't come to the Solitude Road property. So they work for Dobson Lawn Landscaping, they help Timmy in the field, but they don't have a need to come, and, you know, since January, he's been clear, no, don't come to the office. You know, we'll meet you either on the job site or a place that we can pick you up. And I think typically the standard operating procedure is that they go right to the job. I know Mr. Council asked a question about that the last meeting, you know, does Timmy's clients really want people showing up in their personal vehicles? And I talked to Timmy about that after the meeting, and he said, frankly, most of his customers don't care. And since that meeting, I've noticed anecdotally that seems to be the case. I've seen landscape crews in my neighborhood working, and there'll be, you know, a company truck, but then there'll be a couple personal vehicles. So I don't think that's out of the norm. Either way, that's what Timmy has been doing. Also, Timmy's made arrangements to, in some cases, meet these folks off-site. And particularly at Carroll Fuel in St. Michael's, Timmy's friendly with the owner of that property. There's a commercial asphalt parking lot in the back of that property it's zoned commercial, but it's not used as part of the business. And the proprietor there has been gracious to allow Timmy's guys to park there, and then Timmy's crew can meet them and pick them up. That particularly works well if they're working below St. Michael's. A similar arrangement's been made with Tim Miller down Easton Point. Him and Timmy are also friends, and Tim has graciously agreed to, you know, his employees can park there and he can pick them up. It works well if he's going, you know, to Oxford or Trapp or somewhere else. And you know, those aren't binding in terms of we don't have leases, but they're arrangements that for the foreseeable future should work. And if they didn't, I mean, there's other places we could arrange to meet those folks. The key, I think, under the cottage industry standards is those employees are not coming to or leaving from the cottage industry location. I would also point out that Timmy does have one additional employee who's not part of Dobson Lawn and Landscaping that helps him with the nursery. That's Lee. That's covered in one of these notes. So Lee does come to the property regularly, but he's involved in the horticulture business, not in the cottage industry. I mean, even if he were, even if we included him, we're still under the 7 we're allowed, but he's not really an employee of the cottage industry. The next page is our truck inventory. And so under the code, we're allowed to have 5 trucks, and those trucks are listed there. Timmy had additional trucks, most of which were used as part of the tree work, but either way, those trucks have been sold. I initially put this together for the March meeting, and I think at that time we still had 2 additional trucks, but those have since been sold. So at this time, I think the only trucks on the property are the 5 listed here, and there is one truck that was damaged. It's no longer operable, and it's going to be removed from the property once an insurance claim settled. But we have these 5 trucks. There is one additional truck, this 2007 International, which is used for the nursery business. It's not used for the cottage industry. The lettering's been taken off. And we'll see on the trip counts, that truck is used not on a regular basis, certainly not a daily or even weekly basis. It's just used occasionally when Timmy needs to bring plant material into or out of the permitted horticultural use on the property. The next 3 pages are monthly reports of trip logs. So Margaret, who manages Timmy's office, has been keeping track of the truck traffic coming in and going out of the property. And we've provided counts here. And so each of these, a trip in is 1, a trip back is, if you leave in the morning, that's 1, you return in the afternoon, that's 2, right? And so under the code, we're allowed 10 truck trips per day. You can see in February, there were no days that we had that number of trips. We were always below that. Admittedly, February is a relatively slower time of this industry. Also in the footnote there were a couple of days where there were some plant deliveries for the nursery. I think one day that the truck came in and went out the same day, the nursery truck. There was another day, it left one day and came back the following day. I think it had gone to North Carolina to pick up some plants and to bring back to put in the ground. But you can see the level of activity for the nursery is very low. And then in March, there certainly was a ramping up, but again, there was never an occasion where we exceeded what's allowable. We have 5 trucks. The idea is that if all 5 are going to be used in a given day, that they go out in the morning, they do all their work, they come back, so we don't exceed the truck trips. And that's worked well. I think in the past, there had been some more coming and going. The same truck might come back and go out, but Timmy's been very clear that moving forward, this is how we have to operate. And it, for 3 months now, 4 months, it's worked well. You can see in the month of March, we had 4 days where the nursery truck was used. Those are listed there in the footnote. Then in April, certainly, sort of prime time in Timmy's business, you can see, there was admittedly more days where we got up to the max. Again, that's just all 5 trucks being in service, all 5 going out in the morning, all 5 coming back in the evening. But again, importantly, we're not exceeding what's allowable. And you can see some days we're less than that. Some days not all the trucks go out. Some days they do, and that's what we expect moving forward. Again, that's what's allowable, under the code for a cottage industry. So we think with this information, we've demonstrated that Timmy can, and he certainly commits that he will continue to operate within what's allowable under the cottage industry. Certainly the county would continue to, monitor that and to enforce its regulations. And we understand that, and frankly, we welcome that.
Yep.
So with that, we're happy to answer any questions you may have. We hope that we've, satisfied the commission's questions about, understanding that in the past there have been exceedances. I think we now have demonstrated that we can and will continue to live within what's allowable under a cottage industry.
Okay. You want to hear from the public first?
Well, so I got a couple things.
Sure.
So my first question is for Brennan. So Brennan, is this property approved as a nursery?
No, there's been no application for approval or any memorialization of an establishment of another use on this property since the previous owner's ownership of it.
And it's part of our site plan that's before them today.
I understand that. He's asking if there's a prior approval.
A prior approval, I'm sorry.
There's no prior approval at this point in time to our knowledge.
Right,
So.
but it's included in our site.
Yes, it's included in your site plan application. So if it were ruled on and approved.
So the second thing is, I don't know, you've given us some information, and I don't know if we want to offer that to anybody in the general public to take a look at that may question it or have questions about it. I think it would be, with the impact, I think that would be appropriate to offer that. If anybody, is that?
I think that's fine.
So I guess what we're saying is, Mr. Smith gave us a handout, and I guess if anybody in the audience would like to take a look at that, in case they have any comments or questions, we'd like to make that available to you. So in the meantime, let's talk about the non-resident employees listed. So we got Margaret, I think you said she's the office manager. Okay. How about Eric? What's he do?
He's a manager.
And so what does he manage? What's he do?
He just floats around, goes between crews, gets some materials if they need it.
Does he figure jobs, do jobs, or just work with the crews?
He just works between crews.
Okay. How about Austin? What's he do?
He's a foreman.
Same thing, just works with the crews?
He works with the crews.
No design work, no planning? Okay, got it. How about Rolando?
He's a foreman.
Foreman, same thing? Okay, and Bear?
Foreman.
Okay,
Same thing.
same thing,
Mhm.
okay. And those are the ones that report to the site daily?
Yes.
Okay. So when you were here before, you talked about one employee as a mechanic. And I thought maybe you said that was Lee, was the mechanic?
No, it was Mike Kemp, and he's not with us anymore.
Do I now?
It was Mike Kemp, and he's not with us anymore.
Okay, so Lee just works with
Lee
the,
works
okay.
just in the nursery operation.
Yep. How about Katie's? Katie's still with you?
She is. She
Yeah.
works remotely,
Okay, she doesn't report to the office?
rarely, just to pick up files or something like that.
Okay, got it. Okay. On page 2, the trucks, you have them listed as a 2014 International. What's the size and gross vehicle weight of that truck?
Not off the top of my head, I don't know.
Take a guess.
I have no idea.
Is it a over 26,000 pounds?
No. That's a
Okay.
bigger truck.
Is it a pickup? Is it a 6-wheel truck?
It's a one-ton dump truck.
A 1-ton dump, okay.
That's what they all are.
They're like pickups with dump bodies. He's not hauling large materials. I mean, these are vehicles you would put sticks and debris from property maintenance projects in, or maybe haul mulch or something
Okay.
like that.
So all these trucks are 1-ton trucks, some with dumps, some with not?
They're all dumps.
All dumps,
Mhm.
okay. Okay.
Mike, you got
And
anything?
Mr. Counsel, last thing I'd say on that, I don't know if it's helpful, but from my observation, they're all consistent with, like Thompson, for example, that I know the commission has approved. They're similar trucks to that you see other landscape contractors use.
Yeah. So I guess, and I haven't been to the site, I don't think, since last year. I don't think I've been down there. But anyway, there were a number of, I would call them mid-sized trucks. In other words, they were more than a ton truck, but maybe not a 26,000 gross vehicle weight truck. None of that, you don't have any of those anymore?
They're just, I don't know what the GVW is on them off the top of my head. They're just consistent with what you've approved in the past, the whole council's approved in the past. It's the same
By who?
exact trucks.
Who approved them in the past? We certainly
I
didn't.
guess you guys.
No,
mean,
no, I
it's-
don't think so. We
it's the
haven't
same
approved
as-
anything for you.
It's the same as Thompson has. It's the
You're
same
saying
as.
they're the pickup style with a dump body or a stick
Yeah.
body?
It's
Or
a
dump
cab
body.
chassis.
So you're saying some of these trucks that you did sell were part of your tree?
That's right. Yep. They were the larger trucks.
They're all
I don't have
gone?
them anymore.
Okay. Got it. Okay.
How many trucks have been sold since the December meeting?
I don't even know, honestly, off the top of my head, I really don't know. I've sold over $500,000 in equipment.
But just ballpark, I mean, are you talking
Maybe,
2 trucks, 5 trucks?
maybe a dozen.
Okay.
How many crews do you have on a maximum day? On your busiest day, how many crews do you have out in the field?
5.
5, okay. And how many employees you generally per crew?
1 or 2,
Okay,
depending on what it is that they're doing.
okay. And no one except the 5 people listed come in and out of the property or use that road?
No.
Timmy and his son, who reside there.
Right.
Yeah.
So, when the truck leaves in the morning, it does not come back until the day's work is done.
That's right.
Is that what you're saying? Okay, because one of the, there are a lot of concerns that I have about the cottage industry definition of what has existed there in general, about the primary use being for your personal residence, as opposed to the primary use being for your business. And I'm glad you have a successful business. We all want everyone in the county to do this and be successful. But it seems like offhand that the primary use of you getting the property and of using the property has been and will probably continue to be for your business, and that you're living there sort of as a secondary use. And I have grave concerns about the safety on that private. It is a very small and private road, not built or designed to handle any significant amount of traffic, truck traffic. Honestly, with the 25 lots that were already there, they were there before any of these rules existed, granted, but that whole development down that whole road, in my opinion, would not be approved today. We're already pushing, if not exceeding, the safety factors under today's rules for that role. These are just comments. I don't have any questions with that along these lines.
Can I just respond
Yeah,
to that last point?
absolutely.
Yeah, so I understand your point. I would just point out, well, two things. One, the county council has declared that cottage industries are
Yes.
permitted. There are a whole set of restrictions. None of those state that they can't be on a private road, right? And so if the county council thought that this accessory use is not appropriate for a private road, it would have said so, and it wouldn't be allowed under those circumstances. But
When the
it-
comprehensive plan, that's one of the things we're
So-
required to take into
So I would
consideration.
counter that, Mr. Smith, and maybe Brennan or our attorney can help us out. But I think our job is to look at a site plan and address all those factors such as traffic, safety, parking, on and on and on. So while the county council obviously didn't say a cottage industry could not, could occur on a private road, I think the site plan approval process is up to this planning commission to determine what works and what doesn't. Is that accurate, Andy?
Yes.
But, Mr. Counsel, on what basis? Again, okay, I take your point. But here we have a history where this has been going on for a number of years. There haven't been any issues. It does function. I mean, what's the data to say it won't function? And I think, one, it's important to know that while there is opposition to this use, it's not from the folks that live down Solitude Road. They're not the folks that you've heard from. The folks that are here, Mr. Hikus lives on the other side of St. Michael's Road, and the other folks that we've heard from live on a road that's on the other side of the property, and I think their biggest concern is that the access is going to be redirected, onto their road, right? And so we have not heard from the folks that live down Solitude Road that this is a problem. It's been going on, so I think if there was a problem, we would know about it. I'd also just point out that, in the terms of cottage industry, again, you've approved Thompson for this very similar business, which is on a road that, is very similar in my mind. It's much more heavily traveled. It can't be much wider, and it does intersect on Dover Road, which is at least as busy, if not a busier road, at a stop sign. Very similar. I'd also point out that the commission approved Keith Powers' cottage industry. I've been down there, and that road is much narrower, much smaller. I mean, it's the sort of road, if you meet someone coming, you got to pull off onto the grass. And I took my boat down there to be worked on. And I'm not criticizing any of these decisions. I think they're absolutely appropriate and consistent with what the county council said. Cottage industries should be allowed. But I'm just pointing out that in this case, there is a relatively low volume of traffic associated with the cottage industry. I don't think it's fair to say it won't work on this road. when I think we've proven that it will, and it's consistent with other cottage industry situations that the commission has approved.
Yeah, Zach, I think we're all, I mean, I'm supportive of cottage industries. I want it. I mean, I'm on record from the last time I was here for, it's not about what you're applying for, it's about your track record. And you, not me saying it, you guys admitted that saying, yes, we have not been out of compliance in the past. Yes, we need to sell half of our trucks. Yes, we have a deal in place coming. Yes, this, and it's all gonna change with this application. So my biggest thing is being convinced that it's actually gonna change, because once we pass it and then the community's negatively impacted, I don't get a second shot at it. I get this shot at it to make sure that I believe what you're presenting to me and it works for that community. And, you know, so I'm looking, your information that you put in, I'm looking at the information that the public's put in, and I still have an uneasy feeling about that you're gonna meet the standards of a cottage industry past 3 months from now. I mean, it's just like, you know, when you get caught by your parents, you're good for a little bit of time, but once that time goes on, like, how long does it take us to get back to 12 trips a day, to just, you needed one more bigger truck just to, I don't know, from the track record and all that, my concern is that within a short amount of time, we're gonna be back to being out of compliance. And I admit that what you presented in a 3-month window from your own tracking is in compliance, but through your track record, that's where my concern is. I don't have any, yes, what you're presenting is a cottage industry. Yes, it's legal to have a cottage industry. Yes, the county council has supported a cottage industry. Yes, I support a cottage industry. But I don't support a cottage industry that's been operating out of compliance, which we've all here admitted that it has been.
We acknowledge that, but I
Right,
mean,
I agree.
what's the outcome there, that we can never operate again? I mean,
No, it's not. It's figuring out, presenting us the details in the operation of how you're gonna operate and change in the future to give us confidence that this fits in the community, and we're not just helping a small business succeed, but we're keeping the community at the level that they wanna be. I mean, we have multiple folds of people that are impacted by this. It's not just his business or the one neighbor that's upset. This is a community thing that's what we're tasked with. And when we have uncertainty, it's our job to ask questions and not just say, oh, well, what you presented looks good. Well, what you've done in the past doesn't look good. And what you presented, I see a way to get there. I just don't have faith that we're going to get there. So that's what your job, the task is to convince, I guess, us, or I don't know how they're going to vote, but I mean, convince me that the path you're taking is going to be one that you follow.
I understand.
Or not you, but I mean,
no,
your client.
and that's fair, and I think that's what we're trying to do this morning. And I mean, it's more than us just saying, I mean, Timmy has sold a big part of his business. He's, you know, number of his employees have left his employment. I mean, these are big changes to get into compliance. And also, Mr. Spees, I would just say, I absolutely hear you, and you're absolutely right. We have to live within what's allowable. We have to live within what's been presented. And the county does have a mechanism to ensure that. And I will tell you, in this case, it's not just going to be the county enforcement folks happen to drive by. Mr. Hikus has demonstrated that he will surveil this, and he will make sure that everyone knows if Timmy steps out of line. For months, there was a camera at the end of Timmy's driveway pointing in, which was infuriating to Timmy. Timmy has a 3-year-old daughter, you know, that plays in her front yard, and there's a camera there. And Timmy called the police and complained about it, and they said, you know, it's creepy, and I wouldn't like it if somebody did it to me, but there's nothing we can do about it. But my point is that there will be, you know, he will be held accountable by the opponent.
Zach, I mean, my problem is, growing up on a farm, like anybody that knows the Spees family, like I'm the least mechanical of the farm and know nothing about equipment. So Chip asked a simple question about a truck and the weights, and which one you sold and how much the trucks were. And he said he's in the business for 3 decades, and he has zero idea of the gross weight of a truck. I mean, all we're doing is asking questions, and like in the past and now, I just feel like it's like roadblocks and not answering the question. I mean, and he didn't even say give me the exact weight. He just said ballpark it.
It's not that I have zero answer, it's that I wanted to give the correct answer, and if I don't have the correct information in front of me based off the trucks that are on this list, I don't know what they are, and I don't know what the GVW is. I just know that it's very, very consistent with every other cottage industry that was approved in this county prior to me, not only for this same industry, but other similar industries.
If that's
Name-
your answer,
name-
if that's your answer, fine. I'm just saying, you don't answer the question for me. It makes me uncomfortable that what can't I trust? Like you're not comfortable giving us information on a cottage industry. So I'm fine. You can give whatever answer you want. I'm fine with it. I'm just saying, I'm just giving you a fact why I'm sitting here and uncomfortable.
Yeah,
And you
and I
can take that or
understand.
leave that with whatever
And
way you want.
you bring up the word community a lot, and the community that's on the street has not one complaint about anything that I do, and I've been there for over 5 years. I got really one legitimate complaint, I would say, and that's it.
And to earlier point, just to move back to an earlier point, Zach, to your comment, it's not Mr. Hikas's responsibility or the other people in the area's responsibility to have to feel that the need to check this out, or to, if he's out of compliance. We need to be confident that he wouldn't be will not be out of compliance, because he has been out.
I just understood, and I wasn't trying to put that responsibility on them. I was just
Yeah.
stating, based on recent history, I feel confident that it won't, that the county enforcement folks will have some help identifying if there's an issue. But you're right,
Yeah.
that is not their responsibility. I would point out, though, that, Mr. Dobson did operate without approval. He was called out on that, he paid a fine for that, and he submitted to the process for that, which is this review process. And through that, he has made changes, significant changes to his business to try to fit within that envelope of what is allowed.
Yes, I know he has.
And if
He
the
is trying
standard
that.
is, if you've ever, gotten out of line, then you can no longer operate, that would be a big problem for a lot of our landscape contractors in this community who have been in similar issues
Yeah.
with the county enforcement folks.
Yeah, but this is not just a one-time, one-step out of line issue. He's been out of line. He was out of compliance, it seems, for a lot of years.
Well, I guess maybe talk more to the planning staff about this, but
Yeah.
there was a period a couple years ago where the county enforcement folks sent a lot of letters to a lot of landscape contractors. I think there was one landscape contractor that was complaining about other people, and lots of them got these letters and said you had to do things. And I think many of them, even today, haven't addressed that, and I think the county has tried to work with them because they're not trying to shut down small businesses. They know that
Right.
these businesses provide important services to the citizens of the county. I think Timmy tried to address that issue. Where he was operating before was a smaller location, and he couldn't fit his business there. And so he went out and found a new place and bought a new property. And at that time, he did submit an application, and I know he didn't follow through with that.
Right.
But, I think him, Ricky Leonard, were the two I know that went out and tried to address that and tried to move forward. And Ricky obviously did fully address it with his approval. But there are others that I think are still working with the county to try to address their violations.
So, let's talk about the nursery for a minute. So, correct me if I'm wrong, but you had all the wood chips and all that stuff. You pushed all that off, removed it, whatever.
Yep.
And then the idea was to start a plant nursery there in that area.
I'm already growing plant material, and we've been hauling plant material in ever since I've been there and selling it out.
So you're bringing plant material in and then just taking it out.
I mean, it's a re-wholesale operation. We also plant in the field seedlings to
Okay.
grow for nursery stock.
And when did we start doing that?
5 years ago.
And Mr. Council, the mulch, remember, was part of a recycling use that Timmy had hoped to start on the property that was pointed out. You can't do
Yep,
that. He did cease it.
understood. Yep, understood.
But the nursery is a use, wholesale nursery. This isn't a retail nursery where you or I could go buy a plant on a Saturday.
Yep.
It's a wholesale nursery that sells to Timmy and his competitors.
Yep.
That is a permitted use in the RC zone. I think
Yep.
it's a good use, right?
Yep.
It's a horticultural use,
Yep.
like agricultural production.
Yeah. Have you seen the letter and the photographs that were sent to the planning commission last night?
We just saw them this morning briefly. We didn't get them ahead of time, but we just saw them.
Okay.
I didn't get a hard copy of the photographs. I scrolled through it. Mr. Yelton let me look at his computer. You know, it looked to me like there's a number of non-Dobson vehicles. I don't know, you know, what that's trying to show. It also looks like it was during a snowstorm. You know, and I would just point out that our tracking is about the business. You know, if I can imagine during a snowstorm, Timmy has a snowplow, you know, there may be occasions where he's helping a neighbor out or doing something. I know we talked about that during the snowstorm. That's something you do, and I'm sure it's something Mr. Hikus does, right?
Yep.
So there may have been some coming and going. You know, I don't have the details on that particular date because we just looked at it. I have what's in our data. But looking at those photos, I saw a lot of cars that weren't necessarily Dobson
Yep.
on the landscape. I don't know what that was trying to show.
Yep.
I did read the letter. I would just say in response to the letter that I think Mr. Showalter is continuing to try to, you know, add standards or stretch standards. And I was involved with Ricky Leonard's application. Our firm represented Ricky when he submitted a cottage industry application to the Planning Commission, which the Planning Commission approved. And you may recall that Mr. Showalter also led the opposition against that cottage industry, fighting him. And he made some of the very same arguments that he's making now. The Planning Commission ultimately didn't accept those arguments, and you approved Ricky Leonard's application. And then Mr. Showalter appealed that, went to the Board of Appeals, and you know, I think the Board of Appeals decision on that is helpful here. This is decision 16-1657, where they make the point, you know, again, back to my point, it is the county council, Talbot's legislative body, that determines what uses are appropriate. It's also the arbiter of all conditions in regarding industry. It says Mr. Showalter attempts to further limit the application of this section by engrafting additional, in this case, size requirements, something the council declined to do when it was amended. And so the Board of Appeals found that, you know, no, you don't get to stretch the meaning of these things. You don't get to add additional conditions that the county council didn't indicate, which is what he's trying to do here. And ultimately, the Board of Appeals upheld the Planning Commission's decision. He then appealed that to the Circuit Court, and I think he dropped it before it went much further. But my point is that, you know, the code is very clear about what you're allowed to do and what you're not. And it's not fair or defensible to keep on or stretch these terms and add additional requirements, which is what Mr. Showalter is trying to do.
With the nursery, does the nursery's truck deliver everything to your your nursery, wholesale nursery clients, or do they come?
They come pick it
They
up
come
and
pick it up
deliver,
themselves.
same, either one.
Okay.
It
So,
depends on what they need.
yeah. Okay.
I'd also like to point out about the safety of the road is that I don't know that all of my trucks are what's being seen going up and down the road.
Right.
There's another landscape, site work, construction contractor down the road that,
Down south.
yes, that nobody has even mentioned. There's a guy at the end of my road who runs his cottage industry, which his exit is right on Route 33, right next to Solitude Road. We've had no problems at all on the road. There's been zero issues with us. There's been no accidents at the end of the road that ever involved us or anything like that. The prior owner to the property had much larger trucks than I had. He had, I believe, 6 trucks. I've got his sale contract sitting in my office. If I needed to prove that, I could show you. Alan Bryant gave me the contract, and I've got it all sitting right there what he purchased. And it was a 10-wheeler, 2 6-wheelers, a 6-wheel service truck, a jetter, and a pickup. And it's very consistent with what's still going on the property. He actually made more trips on and off the property than I do for 45 years. It was already basically set up for my company. There's an office there. There's an outdoor area, multiple outdoor buildings. You can't see anything I've got from the road to an extent, very little at all.
Or neighboring property.
Or neighboring properties. I mean, even Mr. Flo came out and multiple other people and mentioned that this was the perfect spot to do what I wanted to do there when I purchased the property. Also, when I purchased the property, I went to Mr. Hikus and had a meeting with him face to face at his property and told him, this is what I plan to do on the property. Do you have any issues with what I'm doing? His response to me was, I don't care for it, but I don't want it to drop my property values on my property. And I told him right then, I don't see how a landscape company could drop his property values in any way near a septic company that's spreading raw sewage on a field for 45 years, up until the county opened up the sewage treatment plant. And that was where it was left. He said he was gonna be a good neighbor, he wasn't gonna cause me any problems or whatever, and I started on the approval process then, and I didn't get the time. He had already started reporting me to the county, so he went back on what he had told me when I met him. So that's how all this all got started. So I felt like at the beginning, when I had the contract on the property and I hadn't settled yet, that was the time to deal with it then, not after I purchased the property and spent $1 million. And that's the facts.
Well, I would agree it's a perfect property for a legal satellite industry, cottage industry. I mean, what the argument is that for years she went above and beyond that, and that's what we have to come to terms with. So, like Mr. Flo saying that it's a perfect property is a valid statement then. It's, what my point is, it's not a valid statement now because people weren't sure, didn't have any idea what was gonna happen there. You've admitted that you've had to sell multiple trucks to get in compliance. You've admitted that took place and we wanted to wait until that sale took place. So yes, for cottage industry, it's a great property. For starting as a cottage industry and growing into what it did is not a proper and it's not a perfect property. So again, we're the cottage industry, I don't have an issue with. The point I have to come to terms with is it gonna remain a cottage industry?
Mr. Spees, that's all we're seeking approval for. I hear you, but that's all that we're seeking approval for. That's all that we're allowed to do there. We understand that, and that's what we're limited to moving forward. But what's the alternative? If you say, you know what, you didn't do right in the past, so you can not even do now what you're allowed to do under the code. I mean, does he shut down? Does he lay off, these 9 people that work for him?
I mean, the alternative is to get into compliance and show a history of compliance.
But I think that's what we've attempted to do today, and if we haven't answered your questions, we want to. We want to provide any additional, but be clear, we're not asking you to approve something that exceeds what's allowable. That's it. That's all you have the authority to approve. That's all that we can reasonably ask you to approve. And then it's incumbent on Timmy to maintain what he's put in front of you today.
He also maintained that shortly after he bought the property, he put in an application for this and then withdrew it. So at some point in time, there was discussion about what the approved use of the property as a cottage industry was. And he made decisions to grow by the number of trucks and employees several times larger than what was allowed if he had been approved as a cottage industry. And at the time, he didn't have approval for anything. So and I think, I don't want to put words into Mr. Spee's mouth, but I think that's what our real concern, one of the concerns of many, but one of the real concerns is he withdrew the application in 2020 and then went ahead and exceeded what would have been allowed had he been approved in 2020. If he had gone through with it and been approved in 2020, maybe things wouldn't have gotten as out of hand because there would have been some enforcement, but he knew he wasn't supposed to do that.
And he's been cited for that. He's paid the fine.
Yeah,
He's
he
submitted
paid the
to
fine,
process.
Right.
but that still stays with the person.
But to what end?
Yeah.
To the
I
end
don't
that
know
you can no longer
until
move to
there's
Dorchester County and
until
run your
there's
business?
a way that everyone can feel comfortable that it won't happen 6 months, a year, 4 or 5 years from now.
How can we do that?
I don't know.
I
That's
mean,
why
I thought that's what enforcement was for.
Yeah.
And it's not about Ed Hikus or anybody
Yeah, no, it's not.
being his responsibility.
Yeah.
It's not tasking him with anything. It's
Yeah.
basically saying, Mr. Dobson, this is what you're allowed to do on the property.
Right.
You're supposed to do this on the property. If I get out of line,
Yeah.
there's
Don't
enforcement.
get frustrated with us when we look back
I'm
and
not
see
getting
what's
frustrated.
happening.
I'm just
Well,
telling you
I
the
am.
facts. It's
I
the
am.
law and it's in the books. It's the rules.
So convince me,
Sorry.
all right, let me ask you a question. The nursery operation,
Mm-hmm.
we'll start with Lee.
Mm-hmm.
That's a full-time position at the nursery, year-round, for
Mhm.
Lee.
Yep.
Okay. Who writes his check?
I'll write his check.
Under what? Under Dobson?
Under Dobson, that's the way any employee that works there.
All your employees are under Dobson Lawn and Landscaping?
Yes.
Okay.
Only because I never had a need to separate it until
You
now.
answered.
No, I think you do. Because if we're gonna run a wholesale nursery, then it is a wholesale nursery. And we can't have all these trucks saying, this isn't Dobson Lawn and Landscape, this is the nursery, this is the nursery.
There's only one truck for the nursery. One truck.
And I can switch his pay over, start the day.
No, I think you're missing the point.
Yeah.
I hear you.
I think you're gonna use, now, based on the past, I'm concerned that you are gonna use the nursery as a way to get around employee limits and truck limits. That's my concern.
Okay. Well, I understand your concern. I mean, what I can say is, one, even if Lee were an employee of the cottage industry, we're still below the number that we're permitted of non-resident employees. So we're permitted 7 based on the parcel size. We have 5. So even if you added Lee, we're still under. But I understand your point. If Lee's gonna be an employee of the nursery, then Timmy needs to separate those two businesses, which he has set up a new business for the nursery.
But I think that's a paper skirt. In other words, you know, I'm not convinced, based off past performance, that this isn't gonna be a way to get around almost all of this, to be quite honest. Employees, trucks, the whole 9 yards.
I'm trying to be upfront about the whole thing. I mean, honestly, it's very easy to open up a nursery, and I could run it as a wholesale nursery. And I can bring from the surrounding counties, every landscaper that runs up and down the road down that property.
No, you can't.
That's not what
No,
I
you
want to
can't.
do.
You could with approval from this board.
If I had approval, yes.
Correct.
But
So
it's a
that's-
lot easier to get that approval apparently than it is for a
Maybe, maybe
I
not.
mean, I feel like
Yeah.
once again,
Yeah.
and I brought this up the last time, Mr. Speeds, that I'm being penalized for buying a property that fits what I needed to do.
You're coming under scrutiny for what's happened for the last 5 years.
Since
I
you-
So
understand
don't point the finger at us. We got a job to do.
I
And
get
what
it.
happens is, Timmy, what happens is when something comes before us and somebody looks at the zoning ordinance and they said, well, here's an opening in the zoning ordinance. If you don't like what I'm trying to do, then tighten up the zoning ordinance. And that's exactly what we've done with the cottage industry. The cottage industry was designed, if you go back and look at the record in 2016 under the comp plan, this commission said, okay, we need to find a place for beginning contractors, the landscapers, the lawn cutters, the contractors. They're operating, we need to bring this into compliance. And when they get to a certain size, then they can move to industrial, commercial, or some other property. Go back and look at the record. That was the whole intent. You've exceeded that. You're still exceeding it. Now, maybe you need to take
I'm not
15
exceeding
minutes. Maybe we need to take a recess and let you look at the pictures that were sent to our email last night, because they don't line up with the truck trips that you've given us.
They should. I don't know why they wouldn't.
Well, if the dates are correct on the pictures, and they are, pick a day and look at the truck traffic, and it doesn't add up. They don't add up.
We can certainly look at those. I mean, again.
I think
looked
you
at 'em-
need to.
I looked at them briefly, and there were a lot of pictures of vehicles that weren't Timmy's trucks in there.
Yeah. Well, there's nothing. I think everybody on here wants you to run a successful business. I don't think there's any doubt. But, you know, we're kind of, our back's a little bit against the wall with this one, to be quite honest.
And I understand the history, and that's fair. But I guess our question is, what do we need to do? I mean, we understood that if we're outside of that envelope of what's allowable, we need to get back in it. And understanding that it was intended for beginners, but either way, the code allows for landscape contractors of a certain size to operate from their property. That's, you know, Timmy owns this property, he's invested in it, he wants to live there, he wants to have his business there. And so what do we need to do to convince the planning commission that we fit within that box? And, you know, I would have thought we could also have the nursery. I think that's the way, you know, Timmy's got 20+ acres, you know, he can have a small landscape contracting business, he can have his house, and then he's got some additional land. We thought the nursery, the wholesale nursery, which is permitted in the RC, was a good use of that additional land. He's trying to comport, and I understand he hasn't always, but he is trying to comport to what's allowable in the zoning code to keep his employees employed, to continue to service his customers, and to keep his livelihood. And so we think those things work there, that they're permitted under the code. If you're saying you don't feel comfortable with that, you know, what is it that we can do to give you those assurances to make further changes? I mean, we have done a lot. I hope the commission would acknowledge that selling a major part of your business, laying off a couple people, selling trucks and equipment, those are steps to try to get within that envelope. I mean, it's not just me saying stuff. I mean, he's actually taken action to fit within what's allowable. Is there something more that we can or need to do to continue to operate this business?
Well, maybe we should hear
from the public.
and
And
then come back and
Have you-
see if
have you come back?
things align, you know?
Yeah, let's do that. Start on the left side in the front row. Second row.
thank you.
Yep.
Can we make sure Mr. Smith has a copy of this?
Thank you.
Good morning. My name is Victoria Brohan. I'm a colleague of Mr. Showalter, who was unable to be here today. So on his behalf, I'd like to read his letter into the record. I'm writing on behalf of J. Edward Heikes, trustee of the Residuary Trust under the will of James I. Heikes and the Kathryn B. Bauer Trust to oppose the cottage industry site plan application by Dobson Lawn and Landscape Incorporated. The Planning Commission has no authority to approve a site plan for a use that does not conform to the definitions and development standards established by the zoning chapter for such use. The landscape maintenance contractor use proposed by this application does not fit within the cottage industry definition or standards, and the property on which it is proposed does not have adequate road access to support the commercial use. Therefore, the application should be denied. First, a cottage industry is designed as an accessory use. Section 190-78 defines an accessory use as a use of land or of a building or a portion thereof which is incidental to, subordinate to, and may customarily be found in connection with the principal use of the land or building and which is located on the same lot with such principal use. Consistent with this categorization, Section 190-33.5B3 specifically provides that no more than one cottage industry per residence or lot is permitted. The use shall be incidental and secondary to the use of the residential dwelling. The terms incidental and secondary are not defined by the county code, but their common meanings are as follows. Incidental is accompanying but not a major part of something, being likely to ensue as a minor consequence, and secondary is one occupying a subordinate or auxiliary position rather than that of a principal. In general, the county's cottage industry use was intended to accommodate uses that are truly incidental and secondary to a principal residence, such as a craftsman with a workshop at his home, an electrician who works out of his home with a van or two and a small crew, or a waterman who distributes his seafood harvest from his home. This use was never intended to permit multiple commercial uses to operate on a single parcel with multiple rental apartments in addition to a principal residence. The terms incidental and secondary relate to the extent and nature of the activity on the property, which can consider, among other things, the relative vehicle trips generated by each use, the relative land and structure area occupied by each use, and the true purpose and operation of the property. A commercial business that operates in multiple accessory structures with large impervious surface areas and vehicles, equipment, and activities that potentially overlap with a commercial production nursery is not in any way incidental or secondary to or customarily associated with the use of the property as a residence. Additionally, as an accessory use, the cottage industry must also comply with the definitional requirement that it may customarily be found in connection with the principal use of the land or building and which is located on the same lot. There is not likely another single property in Talbot County that is improved by multiple non-conforming rental apartments occupied by employees or non-employees of commercial businesses. Certainly, the factual circumstances presented by this application are not customarily found in connection with the use of land as a principal residence. During the applicant's appearance before the Planning Commission in December, it was acknowledged that the subject property was purchased for the dual purpose of his residence and the business. This acknowledgement confirms what is plainly evident from the site plan. This is a hub of commercial activity that happens to include a principal residence. If the multiple rental apartments were vacated and eliminated and complementary commercial nursery use ceased and it was solely Mr. Dobson's residence, perhaps he could present a different application. But the record before the Planning Commission clearly demonstrates that this use does not satisfy the threshold definition limitations on accessory uses. As such, the application must be denied. The cottage industry requirements also mandate that the property contains the primary residence of the proprietor of the cottage industry. If the proprietor of the business is not the property owner, the application must include evidence of permission of the property owner to use the property for the cottage industry. The property was recently conveyed to Top of Solitude LLC. The applicant is Dobson Lawn and Landscape Incorporated, which previously suggested that Timothy Dobson was the resident and proprietor. Without evidence who owns each entity, whether such individual's principal residence is on the property, and potentially a lease from Top of Solitude LLC to Dobson Lawn and Landscape Incorporated, the application does not comply with the cottage industry requirements. In light of presentation of evidence that both the number and sizes of vehicles coming and going from the subject property substantially exceeded the cottage industry standards, it was reported that the applicant was scaling back his manpower and equipment, and the business would be dramatically different in 60 to 90 days. The representation was appropriately met with skepticism based on the applicant's consistent history of disregarding the zoning ordinance and failure to bring the property into compliance over an extended period of time. Despite the suggestion that the applicant was reducing its manpower, its Facebook page and website have advertised employment opportunities for several months, noting the latest was in March of this year. Earlier this year, when it was apparent that the downsizing and vehicular compliance representations were not being honored, Mr. Heikes installed a camera on the trust property to document the vehicles entering and exiting the subject property. A short snapshot in time is provided through the attached photos, which illustrate that the volume and sizes of vehicles continued to violate the cottage industry restrictions. Occupants of or visitors to the applicant's property generated lots of images on these cameras by shining laser pointers on the cameras after dark. Additionally, as if having the burden of documenting noncompliance is not enough, unidentified people harassed Mr. Heikes and his family by shining a similar laser pointer through the windows of his home from Solitude Road. The last page of the attachment includes a screenshot of a Facebook post, which illustrate the applicant's response when faced with the possibility of being held accountable by the presence of these cameras. Shortly after Mr. Dobson's social media post, the cameras were stolen from the trust property by unidentified trespassers. Finally, I urge you to deny site plan approval for this proposed cottage industry under the sections 190-60.1A, 190-60.6D and E, 134-10A1C, and 134-10A2A of the County Code. The site plan process ensures that proposed development conforms to the purposes, standards, and requirements of this chapter, as well as other county, state, and federal requirements applicable to the use and development of land. Among other considerations, the Planning Commission is charged with considering the adequacy of access and traffic circulation, which may be a basis for denial of a site plan. Solitude Road is a private road that is owned by the trust. A private road is permitted to provide access to not more than 10 residential lots. Despite the fact that it is a private road, Solitude Road currently provides access to 25 lots because they were subdivided prior to the establishment of the county road standards. The only way to increase the number of lots to utilize a private road is by the county council's approval of a resolution which may be adopted only if the road meets county standards for publicly owned roads and the number and type of lots to be served. To serve the existing non-conforming lots and the proposed use, Solitude Road must be improved to the standards for a minor public road, and such use must also be approved by the county council. The existing right-of-way width is not close to 60 feet, and the trusts are unwilling to grant additional right-of-way widening of Solitude Road. Therefore, the applicant cannot provide access for the proposed use in conformity with the county road standards, which constitute a county requirement applicable to the use and development of land. For all these reasons and others articulated, the proposed site plan must be denied. And then I just want to point out, in relation to the truck traffic, the county code does state that no more than 10 truck trips may be generated by a cottage industry, but no more than 4 by trucks with a gross weight of 10,000 pounds or more. And then Mr. Heikes.
All right, I'll go through this as quick as I can. Here are the issues that I see. Accessory use is to be incidental to the use as a home site. This property was purchased for the primary use of this business, as the operation of the business at the old site had been deemed illegal since 2009, as evidenced by the county compliance enforcement notices having been sent to the owner at the old address. Zach Smith stated in December meeting that it was purchased for the dual uses of residence and business. Under 33.5B2, standards for cottage industry limitation of square footage and accessory structures are limited to 5,000 square feet. The site plan shows 7,588 square feet. Under 33.5B8, setbacks for structures and outdoor storage, loading and operation or parking area from neighboring property lines is 150 feet. Currently, there is equipment unrelated to the nursery at approximately 25 feet and a pile of concrete rubble camouflaged by a pile of wood waste chips at approximately 35 feet. Under 33.5B9, the following requirements apply to the area. The following requirements apply to the areas used or equipment rental, material storage, repair work areas, and parking, loading or circulation of trucks with a GVR weight of over 10,000 pounds. Be screened from adjacent properties, public ways, and shorelines by a type D landscape yard or an equivalent combination of setbacks and topography. This circulation of trucks is on a private road, not owned by the business owner, and with no way to screen it. 33.5B10, the truck limits, no more than 5 trucks permitted. I see a cab over 6-wheel lawnmower truck with a van body. I estimate the GVWR of 14,000 pounds for that truck. A cab over 6-wheel Hino or Isuzu with a steel fabricated box dump body. Estimated GVWR of 14,000 pounds. A cab over 6-wheel Hino or Isuzu truck with fabricated aluminum box dump body. Estimated GVWR of 18,000 pounds. A conventional cab six-wheel Dodge with a steel flatbed body, estimated GVWR of 17,000 pounds. A conventional cab six-wheel Super Duty Ford with a steel flatbed body, estimated GVWR 17,000 pounds. A conventional six-wheel Navistar mulch truck with a fabricated steel dump body, estimated GVWR 18,000 pounds. A late model Ford Super Duty pickup, estimated GVWR 10,000 pounds. A conventional cab boom truck used to remove wood chips or landscape waste from the job site, estimated GVWR 26,000 to 33,000. This truck has been relettered as a nursery truck. It is in reality a vehicle used in a service industry. These trucks circulate all day and include the foreman's vehicle, which is a late model four-wheel drive Super Duty truck with an estimated GVWR of 10,000 pounds. Keep in mind that any of these trucks on any day can and are hooked to multi-axle equipment trailers carrying skid steers or small excavators, which will likely push the GVWR of the smallest of these trucks to a combination weight of over 16,000 pounds. And I want to pause here and tell you I've worked on heavy-duty trucks and heavy equipment for 47 years. I have some concept of what GVWRs are. I have estimated the GVWRs here. But if I was here trying to get this permitted for my business, I would have the weight rating that's in the door jamb of every truck in the United States, either on a plaque or a decal. I would have that the GVWR is set by the manufacturer. I would have some evidence here of what the GVWRs of these trucks are, and there is no evidence of that this morning at all. All right, so going on here under B, unless located on a state roadway or county collector roadway as identified on the functional classification of road maps in the county comprehensive plan, the cottage industry shall not generate visits to the site by trucks with a GVWR of over 16,000 pounds. This happens every day. Again, review the info on the trucks above. Please spare me the argument that this has anything to do with a nursery. This is a service business. On any single day, no more than 10 truck trips may be generated by the cottage industry, with no more than 4 trips by trucks with a GVWR of 10,000 pounds or more. This is exceeded constantly. This business is too large with too much traffic to be on this site. There are 25 homes using Solitude Road. There is at least one, and beyond this property, there are 25 homes. There is at least one lot that has not been built on that may use it. And the current standards are 10 dwellings on a private road. If you add this cottage industry with a fleet of trucks and the employees, it's a bit much. I'm not including here the 2 apartments that have not been permitted but do exist on this property also, that the traffic for them is also using the road currently. I do want to go back and discuss the meeting that we had in 2020. We did talk about what was going on here. I told Mr. Dobson I was not impressed with doing this. He did tell me, Alyssa told him to buy the property. I told him make sure before you proceed that you have approvals for this. There is no approval, and there never has been. I think I'm done.
Okay,
Thank you.
thank you.
So, before you guys get up, Mr. Higgis, I assume the pictures we got, they're the ones that came from your camera?
Yes. Ryan asked me to put the camera up in exactly the location it was located after the December meeting, because the narrative at the December meeting was that perhaps the traffic was going further up Solitude Road and it wasn't traffic going into the property or whatever. And he said the only way to iron this out is to put up the camera and have it show the entrance and traffic turning in the entrance of the driveway. So that's why the camera was put up.
Okay. Give me just a minute here. So Zach, I'm probably going to ask you and Timmy to do the same thing. So go to February 25th. So the first one I got is February 25th at 6:41 a.m. Are you there? It's like the 6th or 7th page in. Yep. Okay. Let's start at 6:41 a.m. And you tell me what you see, and I'm interested in the trucks and the gross vehicle weight of those trucks. So just start with the first picture.
You want me to tell you that?
Yep.
This is a late model Super Duty pickup truck, and I would say 10,000 pounds,
Okay.
possibly slightly more.
Okay. Next one. Just keep right on going.
That's a red pickup truck. That's probably under 10,000, definitely under 10,000 pounds. This is his son's truck and is possibly under 10,000 pounds or possibly over 10,000 pounds. Because 2016, I think after 2016, Ford Super Duties were, I think, all over 10,000 or more likely to be over 10,000. This one could be 9,600. We don't know.
Okay.
This is the one on the right here with the aluminum body is that one I had estimated at 14 or 18,000 pounds, I think.
What kind of truck is that?
That is it's one that came from Brian Brown. I said a Hino, possibly a Hino or a Suzu.
Okay.
On the bottom there is the dump truck that's still around that has the box body on it. That is over 10,000 pounds.
What kind of truck is that? Do we know?
Then there's a pickup truck that is not.
Okay, let's go back to the stake body, bottom left. Do you know
Okay.
what kind of truck that is?
That is I think a Hino or a Suzu, one or the other.
Okay. All right, let's keep going. Okay, we got the red pickup. All right, next page.
All right, next page on top is the mulch truck. I think I had that down at 18,000 pounds, four-door, six-wheel truck. On the right is
Do we know what kind of truck that is?
That is a Navistar.
Okay, is a Navistar the same as an International?
Yes, correct, yeah.
Okay. Next.
The one on the right is the Dodge.
Okay.
That is like 17,000 pounds.
Okay.
On the bottom is the truck that is now painted for the nursery. That is a debris truck that was used for the tree business. Apparently Bartlett did not take that. That is used to haul debris.
Okay.
Pick it up off the ground and load it on the back of itself.
What's the gross vehicle on that, you think?
I'd say 26,000 to 33.
Okay, and what kind of truck is that?
That is that's Navistar also, I believe.
Okay.
Maybe Freightliner, I'm not sure.
Yep. Okay.
On the right is the foreman's truck. Again, that's a late model F-250 or F-350. I would say over 10,000 pounds on that one.
What kind of truck we think that is?
That is a Ford Super Duty.
Okay.
Then this gray truck is some employee's truck.
Okay.
Again, the mulch truck coming back.
Same mulch truck, right? Okay.
And the gray truck coming back.
Okay.
And the mulch truck leaving.
Yep.
and a car coming in, then the employees, the foreman's truck coming back again, and the foreman's truck leaving again,
Okay.
and then the gray truck leaving again, and then the foreman's truck leaving, and then the foreman's truck coming back, and the gray truck leaving, and the gray truck coming back, and the gray truck leaving, and then the box dump coming back, cab over box dump, and then the gray truck turning in. That might be at the same time. That's a duplicate there.
Yep.
And then we have the foreman's truck coming back at 2:11, gray truck leaving at 2:13, the Dodge coming back at 3:11, the gray truck coming back at 3:21, then red truck leaving and the car leaving. Then again, the Super Duty leaving at 4:12. That is his son's truck, yeah. And then we have the mulch truck coming back at 4:29. We have another employee car leaving at 4:33. And we have the cab over with the aluminum box body coming back at 4:35. The gray truck leaving at 4:42. The foreman's truck leaving at 4:50. Here is this red car and another red truck leaving that are employees' cars, I would assume. The gray truck coming back again, and then the gray truck leaving at 5:12. And
That's good enough. The other two are in the dark. Okay.
that gets us to dark.
Yep, that's fine.
All right.
Yep, okay. So, Mr. Smith, at some point, I'm going to afford you the same opportunity to respond to all that.
Anything for these two?
Pardon?
Anything more for
No.
these guys?
Not for me.
Anybody else from the public?
Good morning.
Good morning.
Ramon Gross. I'm the property owner at 25757 Royal Oak Road, which abuts Mr. Dobson's property. I think that there's a general consensus, at least a majority consensus in the room, that we're finding it hard to trust the representations made today that Mr. Dobson will continue only because of his past, and he's himself, his actions have brought himself to this. It was just in October of 2024 that he began to fell trees along my property line, and I don't know how many trees, maybe 20, 30 or more trees came down, and nobody knew what was going on. We went to the state, we went to the county, and it was determined that he had a permit, but he was doing it in violation of the permit at that time. For reasons unknown to us, he has stopped that development. That is my main concern, and the main concern of other neighbors that abut his property, is that he's going to use that right-of-way, develop it, and use it for his business. So that's one of the things that we would want excluded explicitly in this site plan approval if it were to go forward. One of the questions that Mr. Smith asked is, what can we do to make this go forward? Well, in a letter that I wrote to the Planning Commission, or to the Planning and Zoning Board, I offered some ideas in that regard. Now, I think they're probably unorthodox ideas, but I think that in this situation, again, Mr. Dobson has brought himself to this because of the fact that he applied for a cottage industry in the past. He knew what was required. He withdrew voluntarily his application, and then he continued to grow his business in violation of the law. So we know there's a history there, and so legitimately we have reasons to mistrust any representation that he makes today. So what in terms of human behavior, what might incentivize Mr. Dobson to actually comply in the future and not do what a lot of us think is a possibility, which is that he gets approved and then he starts using, for example, the nursery to grow the business on the property, or some other way. Look, he's clearly a brilliant businessman, and we all want to see him succeed, but we want to see him succeed in a manner that does not affect the community in the way that we all fear it will if he continues with an approval today. So what are those incentives that I had proposed? Yeah, they might be unorthodox, but one, he can't approve, he can't agree that if he is in violation of the approval, he will pay a $1,000 fine, strict liability. If he doesn't agree to that, the question is, why not? I mean, if you're here telling us today that you're going to comply, that you're not going to violate in the future the way that you have done for the past 5 years, then why wouldn't you agree to something that is not going to happen?
So this commission doesn't have the ability to do that.
So again, it's unorthodox. I know that the code doesn't allow it, but he himself cannot offer to make that as part of his application for the commission to approve?
I don't think we
I
have.
would defer to the attorney, but I don't think that's a road we're willing to.
I don't know I'm an attorney, but I don't know the answer.
No, the planning commission doesn't have authority to set that kind of condition.
Even with the applicant's consent?
No,
Okay.
correct.
Okay. The other thought that comes to mind, and this might fall within the same area, is Mr. Dobson agreed to pay for the surveillance of his property. I mean, I don't think the county has the ability. I mean, I think the county has shown, I think in the past, that they just don't have the ability to monitor, all of the violations, obviously, in the county. But Mr. Dobson's property specifically, has gone on for so long, and then it's just. The taxpayers are paying for it. Today, there seemed to be some suggestion that because the neighbors, Mr. Hikus in particular, has been monitoring the property recently, that Mr. Dobson has more incentive to move forward and comply. But it's not Mr. Hikus's responsibility to do that, nor is it mine. I have deer cameras in my backyard, and I've caught Mr. Dobson's employees walking through my backyard when they were cutting the trees down. Now, when I had the sheriff go over there, they stopped it, and I appreciate that. But again, it's not our responsibility to do that, So, we just expect our neighbors to comply with the law, and not overtax our county resources or the resources of neighbors. And so, I don't know if there's some way that Mr. Dobson would be able to consent to pay for the surveillance of his property, the monitoring of his property for some time, 3 years, 5 years. I don't know what it would be, but if that's a possibility, but I think that there needs to be some incentives here. If there are not incentives, then I find it difficult to support this application. Thank you.
Thank you. Excuse me.
Good morning. My name is Chris Holden. I'm the property owner of 25781 Royal Oak Road. I'm Ramon's neighbor. My property abuts the right-of-way through Mr. Hikus' property that currently is not on the site plan. It was on the original site plan submitted by Mr. Dobson in 2020 that we've all understood that he tabled the application for. Again, I've said in previous meetings and in letters that I've submitted to the county, I don't want to rehash everything, but this is nothing against Mr. Dobson's business or any business in Talbot County. It's about protecting my interests as a property owner, protecting my privacy, specifically from use if the right-of-way were to be developed at some point, which I understand that it's not on the site plan at this time, but based on mistrust that we've built over years, I don't have confidence that that isn't down the pipeline should approval be granted today. Moving forward, I've gotten estimates to put a fence up along my property line where the right-of-way is to screen my yard, and they range from $15,000 for a 6-foot fence to $24,000 for an 8-foot fence, which I understand an 8-foot fence isn't permitted by the code without exception, but that's the amount of money I'm looking at investing personally if this gets approved and then that were to happen, where that right-of-way starts being used. Again, those trees were felled, the lot was cleared without Talbot's county soil conservation approval. This is not, as Mr. Stranahan said, a matter of one time varying beyond what's permitted. This is a string of events for, some would say since 2020 at this property, beyond that at the previous property. of noncompliance. There was an abatement order issued in 2021 at this current property. Satellite imagery from Google in 2022, 2023 continues to show the expansion of use on the property, clearing lots, or portions of the lot rather, expanding the operations, increased number of trucks, despite having an order of abatement after tabling his application in 2020, and then no activity for 3 years until 24, when myself and the other neighbors called the county, called the state, because all the trees around our houses were being cut down, the stumps ground down, and we had no idea what was going on. The trees still lay around my property to this day. It looks terrible. So I might put the fence up either way, just because it, you know, you have family, friends over, just the trees along the property lines, just, they look bad. It's certainly not the aesthetic that the property was when I purchased it, where I was just surrounded by woods. And that was part of the appeal of that property, is Mr. Dobson had his reasons for buying his property. I had reasons for buying mine, which are now being adversely affected by his. You know, I spoke in my letter I submitted in February prior to the March meeting that there was Facebook posts, and the website said that they were hiring, growing the business, despite Mr. Dobson and Mr. Smith saying at the meeting in December that they were doing everything they could to downsize the company to get in compliance. So when you see that they're hiring, I understand that those employees don't have to necessarily report to the site, but when we're told in December, I don't want to lay off people, I don't want to downsize, but I will if I have to, and then you see ads on multiple avenues for hiring employees, it sort of goes against what was said in December, which again builds on that mistrust that we're going to do the right thing and continue to do the right thing. I've also have the same sentiment that I feel that the nursery business is sort of a Trojan horse, if you will, for the landscape business, so that it's, well, this is a landscape trip to use the nursery as a means to exceed the cottage industry requirements for truck trips, employees, et cetera, by saying it's a nursery operation, which I think we spoke in some extent about at the December meeting. What else do I have here? Again, I'm not going to rehash everything I've put in the 3 or 4 letters I've sent since 2020. I do want to speak a bit about the road access. I understand Solitude Road is a private road. I believe it was mentioned that for it to be brought up to the standard needed for the type of traffic on the road, it would have to be a minimum of 60 feet wide for it to be considered a public road. And then you get into landscape buffers for truck circulation. So just to speak on that, if it were to push, I know the alternative to Solitude is the right-of-way, which was on the original site plan, not on the current site plan. But I just want to state that in my 2020 letter, that the Type D landscape yard are required to screen the adjacent properties from the truck circulation. I don't think that's feasible in the right-of-way, which is 50 feet. So if it can't be done on a public road that's 60 feet wide, it can't be done in a 50-foot right-of-way. I also believe that the deed to the property, if Solitude were to become public, that the right-of-way would cease to exist, which, you know, that would be, you know, my silver bullet would be that if it was a public road, then the right-of-way fails to exist. There's no chance of that being developed and adversely affecting my property. I don't know that that's ever going to happen. Maybe not in my lifetime, maybe not ever. But again, my primary concerns are just protecting my family's interests, our privacy. You know, the right-of-way is right behind. We have the smallest lot on that road. It's 3-acre lots, and then ours is 1. The right-of-way comes down adjacent to Mr. Grouse's lot behind my backyard, and it's, you know, 80 feet from my windows into my bedrooms, bathrooms, etc. You know, a 6-foot fence, 8-foot fence isn't going to help screen visibility from a truck in that right-of-way up into my bedroom and bathroom windows on the 2nd floor of the house. It would help, at least when you're down in the backyard or on the 1st floor. But again, that's me incurring tens of thousands of dollars in costs just to protect something I had when I purchased the property. So this is nothing personal against Mr. Dobson's business. This is not, you know, I don't want to get into the, you know, the truck counts, except I will say that, you know, the self-reported numbers, in my opinion, is sort of the fox watching the hen house. You know, if they're self-reporting their numbers, and as Mr. Gross stated, it's not Mr. Heikes' responsibility. It's untenable for the county to have to surveil a property to that extent to monitor the number of truck trips, but also given the history of decisions made to expand the business after it being issued an order of abatement, after being not in compliance and tabling an application, you know, taking those numbers at face value and accepting them as truth is a hard pill to swallow. And then same thing with the truck weights, that, you know, there's limitations about no trucks over 16,000 pounds, no more than 4 trips for trucks over 10,000 pounds, but we don't know the weights, and we've asked for them. I think it was mentioned at the December meeting that, you know, that's not an unknown, that's not something that we're all just hearing about today, that there's limitations on the trips based on the truck's weight, but that information hasn't been provided for, you know, the planning commission to make a decision based on. So I would just ask that, and I'm sure you will take all that into consideration when you make your decision. I don't know that I'll be able to stay for the outcome of this since I have to get back to work, but I appreciate you lending me your ears for a few minutes to give you my opinions, and thank you.
Thank you.
So I have a legal question. So as the holder of a right-of-way, Mr. Dobson has the right to use that right-of-way. In other words, it's an established right-of-way. He has the right to use it if he gets the right permits to clear the trees and put the road in. Is that correct?
I believe so, yes.
Yeah. I mean, I don't think we can say, no, you can't use that right-of-way. I don't.
I would agree with that.
I mean, I think it's an established right-of-way, and it's his right-of-way.
That's right.
Okay?
Yeah.
Just trying to be clear. Yep, okay.
Zach, would you want to come back?
Thank you, Mr. Corson. I know you may have questions for us, but I just wanted to touch on a few of the items real quick if I could.
Please.
First of all, on this right-of-way, I mean, it's true, there is a right-of-way to the other road. It's also true, and as we stated before, you know, Timmy's preference is not to improve and utilize that. The only reason he was considering it was because one of the opponents, Mr. Hikus, my understanding is he suggested that to Timmy as a way to, you know, I guess certainly address his concerns. The problem with that is that it offended some of the other opponents here. And so I think Timmy's position on that is that if that's the only way he could continue to operate, then he would have to do what he has to do. But his preference would be to continue to use Solitude Road and not to improve that. We disagree with Mr. Gross's characterization that that was a violation. Timmy did have a permit to do that clearing, and the reason he went in to do it is because it was about to expire.
Mm-hmm.
He had gotten it, you know, at a time where he thought, okay, this is the solution, I'll improve this other right-of-way as my access and everybody will be happy. He found out everybody wasn't happy, and so he kind of backed off. And again, if that's what he has to do, that's what he will do, but his preference would be consistent with, I think, Mr. Gross and Mr. Holden is not to do that and to continue to use Solitude Road. I wanted to talk quickly, I know we got to talk about this gross vehicle rate rating and the trips from the photographs, but if I could just touch on these other points that Mr. Hikus made. Let me just see if I can find his. In terms of this notion of what's incidental to what, I mean, you know, this is Timmy's home. This is where he lives. And he runs his business from that as well. And that's, you know, what a cottage industry is. And I don't understand this notion of which one are we going to characterize as the larger of the two. I think Mr. Council commented at our December meeting that, you know, when he steps on the site, it looks like something different than what in his mind would be a small landscape business. And we acknowledge that the buildings that are there exceed what, you know, you would expect to see. And in fact, what Mr. Dobson even uses for his business, right? There's some buildings there that came with the property. And like any property owner, you know, if you buy a property with buildings, you're not going to knock them down. You're going to utilize them, right? And so he utilizes them. He's very specific on the site plan about what portions of the improvements he uses for his business. And it's not everything that sits there. It's, you know, it's the office, the shop, and the yard. And that's listed on our site plan. Similarly, you know, that addresses the second point where he says we show 7,588 square feet of accessory structures. Again, those are not all utilized for the cottage industry. We're very specific on there about what is and what isn't. And I would say that's consistent with, I know, the Thompson application, which I think on that property, there's additional space and improvements. Again, you know, what property owner, I have a shed, 2 sheds on my property, right? You use it for your personal use, and he does the same. I think Timmy testified that his kids, like to buy and fix up cars. He has a boat. There's a number of things he uses those for. In terms of the screening, we requested a waiver. That's part of the application. And I think this site is 20 acres in size. It's well vegetated already, and we think it's appropriate to grant the waiver. But we clearly the Planning Commission has the authority to grant a waiver for landscaping. This notion about setbacks, again, the site plan clearly defines that we comply with the setbacks. The staff confirmed that in its staff report. The nursery use is not subject to the same standards. We're talking about the cottage industry. These are the setbacks for the cottage industry, which the site plan clearly delineates the portion of the property that's being used for that and demonstrates compliance with that. In terms of trucks and truck traffic, I think that is certainly something we need to talk about. So first, let's talk about the photographs. We went through this, and let's be clear about what the code says. The code says that we can maintain 5 trucks during non-business hours on the property, which we would contend we comply with. Now, we do have the 1 additional truck for the nursery, and I know there's some skepticism about that. But I would say, it's reasonable that to the extent we're allowed to operate a nursery on the property, that there could be a need for a truck to utilize with that. Just like a farming operation, there are going to be trucks. We're not talking about something that's coming in and out of there every day, 10 times a day. I think the data we provided is very minimal. So we would maintain that we do comply with that. We have a number of trucks that fits within. Those are the trucks that are used for business. We have 1 additional truck that our position is part of the nursery and not part of the cottage industry. If that's a problem, then that's something I guess we're going to have to address. In terms of these photographs, there's a number of vehicles coming and going from the site. This limitation on 10 trucks very clearly excludes, employees, commuter vehicles arriving and leaving the job site.
No, I don't think it does.
It does. It says, on a single day, no more than 10 truck trips may be generated by the cottage industry, excluding
So mine says including.
Mine says excluding.
It's excluding.
So my,
Where are you reading?
I'm reading out of chapter 190, my book.
Oh, really?
Yeah, it says including. Okay.
Mine says excluding
Okay.
employees, commuter vehicles arriving at or leaving the
Big
site.
difference.
It's a big difference.
There's no more than
Can we
4
get
trucks.
clarification on which one that is?
I'm looking at, this is the code, I'm looking at
It's excluding.
190,
It is.
33.
It's
Okay.
excluding. If you look at the E-code version of it that we have online is the most up-to-date and current version of the county code. That section, subsection that you're referencing, 10C there,
Yep.
was amended on 7/9/2019 under bill number 1412. I don't know if that clarified that language or added that language, but
Okay.
that is the most recent language, and it does have in parentheses there excluding employees, commuter vehicles arriving at or leaving the site.
Okay. Well, that's an important one.
That is.
So
Okay.
setting aside the weight, which I know we need to talk about, and we will talk about that in a second. I run through this, and to me, I see where we're in compliance. I see 10 truck trips. I do note that our information says we had 8 that day. That's a discrepancy. I acknowledge that. But we have 10 truck trips. We have an 11th trip, which is the nursery truck, which we stated in our data. We said that came in that day or went out that day. We have a picture of that. Otherwise, we have 10 truck trips. Now, we don't believe that the foreman's truck is included in that. That is his commuter vehicle. But if we need to better understand that, let's talk about that. Let's figure that out. If that's a limitation where that truck coming and going counts, I would hope that him showing up in the morning and leaving at night wouldn't count because that's his commuter vehicle. But if he comes in and out of the shop, if he goes to lunch or he runs something out to a crew in the field, if that counts, we need to understand that. But our understanding from the code is we're talking about 10 truck trips, which are the 5 trucks we're allowed to have for the business, coming in and going out of the site each day. A lot of these pictures are of Timmy's vehicle, Timmy's family's vehicles, and just like we all come and go from our homes, he's allowed to do the same thing. Even if Timmy's son's truck technically is 10,000 pounds. I would hope that wouldn't count. This young man lives on the property. He comes and goes there. You know, he's allowed to do that. So, again, I think we're still in compliance there. The gross vehicle weight rating, you know, I understand the point, and I think we need to do some analysis. We need to understand what our limitations are. You know, I think I'm surprised by that because, again, what we're doing is consistent with what we see other people doing, and I know that's not an excuse, but I know those are ones that the county's reviewed, that the county's aware of. Timmy's had many conversations with Jimmy Mulliken, who has worked with him to go through this process. Never in those discussions was the truck weight rating raised as an issue or a problem for him. If it is, then, you know, clearly we're allowed some level of truck activity. You know, maybe we need to find another place to keep one or more of these trucks. You know, again, obviously we have to fit within what's allowable, and we understand that. And based on Mr. Hikis's estimations, it sounds like we may exceed to some level some of that. All I can say is we understand that we're limited by that. I think I'd like to speak with the county council, explain the issue, because again, if what I'm seeing is consistent with what other similarly situated people are doing already, then maybe this needs to be revisited, because maybe that's not realistic. I know that's not for the planning commission to decide, and what's in front of you is all you can act on. But to me, I think, again, the types of trucks that Timmy has, and I'm not an expert, but the types of trucks that Timmy has are very consistent with what you would expect a landscape contractor to have to do the work that they do, and consistent with what other approved landscape contractors already have. So I guess what I would say is we will look, we will figure out exactly what we're allowed, we'll live within that. If we have to sell a truck, or if we have to find an alternate site to keep the truck, I'd like to have the opportunity to talk to the council and see if maybe we can revisit that, not just for our benefit, but for the benefit of other similarly situated cottage industry operators that I think are doing the same thing today. But I acknowledge that that could be something that we still need to address.
Now, the trucks in these pictures, there was a mention of an Isuzu or a Hino.
Yeah, I did want to speak to that because I know that's not on our list.
Right.
Timmy did have, so this 2014 Dodge, truck number 25, Timmy was intending to sell that vehicle. He had an Isuzu that he was using for his business, and that vehicle was in an accident. It's actually still on his property. I don't know if it's totaled, but it's no longer in commission. And so
The International or the Isuzu?
It's an Isuzu. And instead of selling the Isuzu, or instead of selling the Dodge, he took the Isuzu out of his fleet and replaced it with the Dodge. And his intent is to get rid of the Isuzu once the insurance claim settles, but he's not using that
But we
truck.
have two
There's
pictures.
two
in
different ones.
February Of two different ones that are neither one on that list. In other words, there's three trucks in these photos that aren't on that
There's
list.
the aluminum body, and then there's the open
No, it's a
body.
GMC. The other truck's a GMC. Let me see here. Yeah, it's a 2005 GMC.
Which one?
The one with the steel body on it. It's a roll-off.
The one in the bottom.
Yes, bottom left corner.
What's the time on that?
727, is that the photo you're referring to?
734 is the GMC. Is that right, Timmy?
Yes.
That's the one with the steel body with the wood stakes.
Well, 734 is the open body with the wood, and then the 727 is the aluminum body.
Yes.
So the 734 is the GMC,
Yes.
and the 727 is the Isuzu
Isuzu.
that was wrecked and replaced with the 2014
Okay.
Dodge.
Okay.
Great. And can also point out, we brought up the right-of-way and how it is deeded. I'm not, you know the legalities of it, but it's also deeded clearly in my deed that I've got a right-of-way from Route 33 through Solitude Road with no restrictions to my property. I just don't know if anybody knows that. I don't have the copy in front of me, but I'd be more than happy to go get you the deed to look at it.
So, while Zach's looking there, so you got Dobson Lawn and Landscape, right?
Mm-hmm.
LLC. Are you the sole member,
I am.
owner of that?
Yes.
Okay, and then you also have Solitude Road.
Top of
Top of Solitude.
Okay.
LLC. Top of Solitude.
Okay, are you the sole
I am.
proprietor? Sole member, sole proprietor of that. Okay. Is that truck titled under Solitude, or is it titled under
It's under
Dobson?
Dobson now, just because I haven't,
Which truck are you talking
The
nursery.
one
The
that has
nursery
the
truck.
rating
No,
on
it's
it.
not, it's under Dobson still,
Dobson.
because I haven't had a chance to do it. That was it was all part of the tree company, but I've kept that truck because it's a bigger truck and I can deliver anything I want in it.
And that's what you do, you make deliveries with that
Yep.
truck? Okay.
Yep.
So let's talk about the wholesale nursery a little bit more. So you bring mulch in,
No.
no mulch comes
Nope.
into that
We
property?
get our mulch from Johnson's on Longwood Road,
Okay. So what comes in?
plant material
Plant.
from all over the country, literally. We get Oregon, North Carolina, South Carolina, Georgia,
Okay.
you know, all over
And
the
when you
place.
pay for that, are you paying for that Dobson Lawn and Landscaping? Does that-
Currently,
They write
yes.
the check?
Only because it didn't make sense for us to change it all. It was only
Yeah.
for a tax reason. But yes, currently we've always operated like
Yeah.
that. And the vast majority of the time, if it's our job site, we try to get it delivered directly to the job site.
Yep,
But
understand.
if we have other people that want plant material, that come to us for plant material, we'll put it on our order, have it delivered to the shop, and then they'll come to the shop and pick it up.
Mm-hmm. So
Or we'll
how-
deliver it to them, depending on what they need.
Yeah. What's the typical length of time that you would hold that plant material? In other words, do you get it in for a job and try to get it out the next day, the next week?
So that's part of what we do. We'll hold the plant material until the contractor needs it. And it's difficult for them. It's not difficult for us because we've been so used to dealing with nurseries throughout time. We've got called a relationship with them, and we know where to get stuff at. So you have multiple different types of plants, perennials, shrubs, trees. You can't get them all from one supplier.
Right.
So we put it all together to one, so we'll have their whole job sitting there, ready for them to go. They're too small. They don't have the ability to do that at that time. They don't even
Yeah.
really know. A lot of people, I'm not trying to say that
But again,
but they don't have the ability to be able to pull all those small orders together, so we can pull them together.
So typically, how long would you hold that? In other words, when that material comes in?
It could be a day, it could be a week, it could be a month.
Okay. So,
And we have plants in holding right now. Sometimes we'll buy stuff if it's a good price on something, and we'll just hold it.
about?
And then you sell,
We do.
but you sell out to other contractors?
Yes, we do.
Because I thought in December you said that was just for your own use, but maybe that's my mistake. So sorry about that. Yeah. All right. So, I guess, Brennan, I'm going to put you on the spot. So in the table of land uses, under greenhouse and plant nursery wholesale, if we look at 26.2, and maybe this is an interpretation, says, limited to establishments for growing and holding. Does your interpretation mean you can bring plants in and hold them and sell them, or does that mean you can grow them and hold them?
I
Or you
think
wanna think about
typically,
that?
I think typically in the past, what we've seen as far as greenhouses and plant nurseries go, to Timmy's point, how his business operates is that you can hold plant material that you source yourself for wholesale resale purposes. So it cannot be sourced from another location, brought there and sold for retail purposes, but you can source plant material that isn't typically grown in this area and hold that for wholesale
Okay,
purposes.
that's point of
Okay.
clarification. Okay,
Well,
got
while we have him on the spot, let's keep rolling that fact. I don't feel like this is gonna keep going on. So what is the county's plan for whether it passes here or it's appealed, and what's the county's plan on policing this? And just so we're not highlighting this operation, other landscape operations that they're bringing up, because it's coming back. So what, are we just gonna be pass it, and then, like, how are we gonna deal with it moving forward?
So I think, typically in the past, obviously we have an Office of Code Compliance that consists of 2.5 full-time employees. That covers the broad spectrum of the entire zoning code. Physically, we don't have the capability and capacity to sit and watch vehicles and count vehicles and numbers of trips and things of that nature on a regular basis, given the number of businesses that we have operating in the county. So site plan compliance, you know, to the point of what several other individuals have testified here to, is something that we obviously are not aware of unless it's physically present when we go out to conduct a site visit, or if we receive a complaint from an adjacent property owner or a concerned citizen, to which we follow up and open an investigation. We don't have an active list of site plans that we go out on a periodic basis and check and say, okay, are they compliant with X, Y, and Z conditions or these types of standards? It's kind of more so as they're operating, we monitor via pass-by. We don't, you know, sit down, open up the plans, go on site with an owner and inspect on a biannual or an annual basis, so to speak. So if there's an issue with a site or we are aware of an issue, we'll obviously, to the extent that we can, monitor it, cite it, obviously call the property owner or the business owner and let them know what the provisions are, what the requirements are, and seek a remedy for compliance if something is out of compliance. I think a situation where you have something out of compliance that's been out of compliance warrants a different set of standards. If somebody's been fined more than one time, you know, I think that's kind of, you know, the course where we take action and say, if specifically with a site plan, if you're out of compliance with conditions, maybe this needs to be reconsidered or brought back to the original approving authority, whether that be the planning director, whether that be the planning commission, depending on the severity or the magnitude of the site plan. We would then probably seek your input and ask you to consider whether or not that site plan needs to have modified conditions imposed on it, or whether or not the approval needs to be revoked based on the magnitude of the violation.
Yeah, well, this policing, I mean, I don't know how.
I would say
I'm
it
like
would be
good luck with it.
unrealistic
Like, I'm like-
from our standpoint,
Right.
especially when we're considering or talking about things like truck traffic or truck limits. Certainly truck limits and getting numbers off of trucks based on GVWR ratings and things like that are things that are quantifiable that we can better understand. But actively monitoring or surveilling a site through the course of a business day or even a business week to understand whether or not you're meeting those limitations is something outside of the scope of what we could do on a regular basis, is something I would say.
I'm glad you're confident that that's something ascertainable, because, you know, they have 5 crews, so that's basically with 5 crews going out and coming back in, that's their maximum number of trips. So then any other trip is out of compliance. So like, how are you going to determine as the county,
Right.
the landscaping, the wholesale nursery truck that goes out to deliver a load of mulch or go pick up a load of mulch and deliver it and then comes back? Like, how are you going to, as the county, going to protect the rest of the neighbors, saying, they're like, well, that truck is going out on wholesale nursery business?
Yeah, I think that becomes a unique component to this all its own, because I don't think in the past we've dealt with cottage industry uses that also contain an additional ancillary use that's permitted by right in a zoning district, not subject to, you know, the regular provisions of the parameters of a major site plan. So I think that would be a difficulty for us, especially if we're talking the difference between marked and unmarked vehicles, and whether or not there's 2 separate business entities kind of conducting business on the same property. So that would be, I think that component of it would be difficult for us to determine the difference between those two.
Yeah, I just don't know how, like, on a regular day, when you, like, their numbers are showing that they're at their, close to or at their maximum number of trips, running any type of business, not on a regular basis, having to have an additional trip in or out. So even looking at the numbers, whether it's from Mr. Hikis or their own, I have concern that there's going to be compliance issues. I just.
So I think there already are. So Zach, in December, you guys stated that you had been working towards compliance for 7 or 8 months. But then we found out that actually we weren't in compliance, but we could work to get there within a matter of days. And that everything would be straight. We'd come back in March, the trucks would be gone, this would happen, that would happen. But then you just sat here and said, well, we probably need to work on that and clarify it a little bit. So you know you've been under scrutiny twice and we can't get there. And as far as I'm concerned, and maybe, again, maybe this is a legal question, but when you have Dobson Lawn and Landscape titled to every truck and every employee, You're not running a wholesale nursery. It's Dobson Lawn and Landscape. I mean, I think if this planning commission approved this site plan, we are setting you up for a disaster. That's how I honestly feel, that if we can't get there in the last 8 or 10 months, to expect that we're gonna get there in the future or stay there in the future, this is going to be a constant battle. It's gonna be. You know, I think we would be doing you a disservice to your business, in all honesty, as hard as that might be for you to understand sitting here today. But I think it's a ticking time bomb.
I think it's a county issue. I look at this situation and I look at the precedent it's gonna set. And when we don't have the answer of how we're gonna police it, because I mean legally the idea is like, well, we're telling you we're gonna do this, and how long can you hold our past actions against us? And we don't have any way to police those past actions. I'm in agreement with Chip, but I have a real concern about how we're gonna handle it as a county, because I have a feeling how some of my commissioners are gonna vote on this, but that's not my real concern. I think some way, somehow, they're gonna get it through and pass, and we as a county aren't gonna have a solution of how to hold their feet to the fire. That's my concern.
Well, the only thing I can say on that is that the the site plan is a mechanism for enforcement.
Yeah,
And that's where I struggle with this is we're pushing it right to the max as it seems, and it doesn't even seem like we're totally there yet. While the monitoring of it and the is very difficult, it does give us some enforcement measures, if there is further noncompliance.
Well, just a quick comment. When I was first looking at taking this responsibility, which we all take seriously, not a job, a couple of Mary Kay Verdry, who was the planning commission, or the head of the planning and zoning at the time, we had some pretty extensive conversations, and one of the things that was key, everything came back to this, that what our responsibility was as commissioners was to try to find a way and work for a way to say yes within the framework of all the rules, all the regulations, everything we had. Do everything you can to try to get to yes before you get to no, because we do want to encourage cottage industries, other industries, commercial industries, and obviously we've been working on this. I think we've all taken this very seriously. The staff is taking it seriously. You guys are working on this, but for all that we've been working on this, we haven't been officially working on it since 2020, but it's been in our minds since 2020. And how do we get to yes? And at this point in time, after all this time, all these meetings, I don't see, for me personally, I've had to vote for things in the past that I didn't want to vote for, but there was a way to yes that was legitimate, that worked within the boundaries, things. And when that's the case, you have to say yes. We haven't gotten there for me. With all this work, all this time, all this discussions, I'm not seeing where we can be at yes.
And this is precedent setting.
Yes.
I'm just saying, because
Yeah, absolutely.
believe me, how people come to us and present to us, we've had it here today.
Yes.
So-and-so did it and got passed.
Right.
So-and-so is doing this and it got passed. X company did this and they're the same as us and they did this.
And
So when we
sometimes,
tie these two entities together
Yes.
and make it and pass it, I mean, legally, it's, I have to do what we have to do, but to say that, the biggest concern for me is how are we going to police it, and this is setting a precedent.
it's setting a precedent, absolutely.
Every
When
little company.
we don't have to
we're gonna
follow-
have to go back and deal with.
We can admit our mistakes, but that's there. And we don't, this is definitely precedent setting.
Yeah, I mean, every little
Yeah.
landscaper is going to be a wholesale nursery
Yes.
next week.
Right.
I
But
think
that's
that
not
would
their
only be
issue.
possible if they fell under the same
Yeah, it's not
parameters as I
right,
do.
and it's not your issue.
I'm just saying,
That's
they
a-
would have to fall under the same parameters I've had to.
It's a permitted use in that zone.
Exactly.
And so they'd have to fit within that same category. And
So
I
then-
just ask, how do you police, other, this
Well-
body approves site plans all the time, it's what you do, right? And so how do you police those? I mean, that's a different action, it's enforcement, it's separate.
So when they're out of compliance, we don't pass
Yeah,
it.
we,
So I would say, when you look at this and you look at the cottage industry standards, Dobson Lawn and Landscaping does not meet those standards. It says it's an accessory use, has to be incidental. You stated on the record in December that you bought the property because it had the office, it had the shop, it had the storage. Now, I don't disagree, and it was, convenient to your customers. I'm not faulting you for that. I would probably try to do it for the same way. But, that's not an incidental use.
How is that not incidental?
Well, I think that was the primary use that the property was bought. That appears to be that. But that aside, we know the trucks don't meet the standards for the cottage industry. We've been working on that. We can't get there. Maybe the employees, maybe not. But, and then again, as Mr. Shanahan pointed to the road, we've got a private road that is at 3 times capacity, and then with the wholesale nursery, you got other trucks coming and going. So, I mean, there's a multitude of things here that again, to me, just don't support it. Don't support this site plan. I'm sorry. I wish, there's nothing I wish more than to say, yep, boy, this is great, good luck, this is, but I
Well, how do
can't
we
get
get
there.
to yes then? I mean, to Mr. Stranahan's point, how do we get to yes? Because, be clear, this is a business, this is people's lives and their livelihoods.
Yep.
This is Timmy's life
Yep.
and his livelihood.
Yep.
He owns this property.
Yep.
I can say he has a legal right under the county's land use regulations to operate a cottage industry on that property. Now, clearly you're uncomfortable with what he's describing, so how do we get it? And if the answer is, we don't like him, he's been a bad actor in the past, he can't do anything, go to Dorchester County, then I don't think that's a reasonable or defensible
I
answer.
agree.
But if the answer is, we need to do something with these trucks, tell us what that is, and we will do it. We want to fit within that envelope. The only thing that I see here that's a potential issue is the gross vehicle weight rating, and I understand that. I still think we have the right to have a certain number of trucks as long as we comply with that. I think we can, with some of our trucks, comply with that. It sounds like we need to make a change and maybe get rid of 2 trucks or take them somewhere else and keep them. I acknowledge that. And we're not asking you to approve anything beyond what you have authority to approve. Your point about, we came here in December and said we've been trying to get into compliance. Timmy's been trying to sell a portion of his business. It takes time to sell a portion of your business. It's not as simple as, selling a truck or something like that. So he's been working on that, found a contract, he found a buyer, he worked a contract. We did in early January, just like we said we were. We settled on that, we closed, and we began to scale back, make this difference.
Yep.
We're here today, I mean, we feel like we fit. I acknowledge the truck weight issue, and we need to address that. I do, I get that. Everything else, I believe that we fit within what's allowable. And we're not trying to point fingers at so-and-so did this, so-and-so did that. We're pointing a finger at the code. The code allows this. That's what we're saying. The code allows this, right? And I don't understand this, well, it's not incidental. He bought the property for dual purposes. When you buy a farm and you live there, it's dual purposes, right? It's a farm and it's a house. Both uses are permitted. The requirement is that he lives on the property. He does live on the property. He meets that requirement. His use, it fits within what's allowable. Landscape contractor, very clearly. He's got very specific standards about the number of employees. He's gotten within that, what's allowable. Number of trucks, he's gotten within that. Albeit, it sounds like we need to address the size of those trucks. And we'll do that. He wants to be able to operate. His nursery business is a use that he's allowed to have by right, subject to site plan approval. And he wants to operate that. The county's already determined that's an appropriate use in this location.
Yeah, but Zach, we're shifting trucks and saying this is for the nursery, but then we're also doing this over here. I mean,
Okay, well, look, if
that
he's got-
is the perfect cover for this.
If he has to get rid of that truck I don't think that's fair to him personally, because I think you're saying, you know, we don't trust you, you're not gonna operate within what, but if that's what he has to do, again, what he doesn't wanna do is he doesn't wanna lay off 9 people. He doesn't wanna fold up his business. That's what he does, and you know, you say
Yep.
we'd be doing you a disservice to approve, you know, don't, that's false. You will absolutely be doing us and his employees a disservice. I'm not putting that on you. I'm just saying, let's be clear about the facts. If you say, Timmy Dobson, you can no longer operate from here, that is devastating.
It's
to
not
this man's
my
business.
fault
I'm
that
not
we're
saying
not
it is your fault.
operating
I'm
within
not
the
saying it's your
standards of
fault,
the
Mr.
cottage
Dobson.
industry.
I'm not saying
I
it's your
didn't do
fault.
it.
I'm just responding to your point, your comment that we'd be doing you a disservice by approving it. That's my only, I'm not putting it on you, and you know, at the end of the day, this is Timmy's problem, absolutely. But we would like to find a solution that allows him to continue to operate within what's allowable, to keep his employees employed, to keep his business afloat, and to personally keep him financially afloat. That's what we're trying to do today.
So when you guys were here last time, we kind of went through the same, so like, what questions do you need to have answered to be in compliance with your vehicles? Because this isn't the first time, the second time, I think it might even be more than the third time. Like, so what questions, Zach, do you need for us to give you directly, for you
And I don't,
to be in compliance? And like when we ask like the gross vehicle weight of the vehicles that are going in, to actually be able to like answer that for us?
I don't even know that we need your information, direction from you. I think what we need to do is to look at the trucks, to figure out how many of these fit within what we're allowed, and we keep that number, and the rest, they need to go.
We
They-
did that in
need
December.
something
I'm
from
done
us,
with it.
like-
I'm done with it, Zach. We did that in December.
Yeah.
You knew what you had, and we couldn't get there. You knew what you had to do.
Mr. Council, we
We're not-
sold
I don't care if,
6
I don't,
trucks.
it doesn't matter. You're not there. It's not there. You just admitted 20 minutes ago that we still need to work on the trucks. You're not there.
Of course, I'm not going to be dishonest with you. I mean, it's
Well,
been
I
pointed out
know,
to
but I
us.
don't know what else to do. You've had since December, and it's May, and we're not there.
And it's not up to us to tell you what you need to do to get into compliance. You see everything you need. From my opinion, from my position, you need to be where you need to be to convince us to say, yes, that this is a good thing, not just for Mr. Dobson and for his business and his employees, but for the neighbors, the neighborhood, the county as a whole, and the county moving forward with the next person that comes along. Bring something that can convince us. You don't have to have me, although I would like to be at a place where I could say yes. But you bring to us what it's going, something that we can, without doubt, say, yes, this is completely within compliance, and we can count on this going forward. Because again, you get through this, what do we need to do? Well, it's gonna take some time to do this. We buy more time. We buy another season. We buy another year. But,
What if we commit to removing 3 of these trucks, and we're gonna have to find another, and we'll do it right now.
I'm gonna have to hear, I need to hear a lot more than just, unfortunately, and it's part of it is frustration, because we started listening to this in 2020, and here we are in 2026, and one would think it's not that complex a requirement that we could get there
We're going
in
off Ed Hikes'
more than
word.
5 or 6
I'm sorry,
years.
but we're going off Ed Hikes' word on what the GVW on these trucks are. I don't know what the GVW on the trucks are. I'm sorry. I
Yeah,
got a
no,
lot
but-
going on in
but-
life.
but you should
the
have-
fact of the matter is, how did everybody else get theirs
But
approved?
I
Hold
do,
on, Tim,
I know, I have I've experienced with trucks as well as several other people do. I don't know exactly what the GVWs are, but I look at the trucks and I have an idea.
So we'd like to amend our application to consistent with our site plan, what we're asking for approval for is to have trucks that meet the limitations. So that's gonna be, no more than, let's be clear about this. So we're allowed 5 trucks total, and no more than 4 of them can exceed 10,000. So we're permitted 2 trucks that are between 10,000 and 16,000. And then we're permitted 3 trucks that are 10,000 or less. And that's what we're gonna do. Because that's all we can do, right? And so that's what we're proposing to, that's what we ask for approval. To the extent that we don't comply with that moving forward, then we're subject to enforcement and fines and everything that goes along with it.
But there's a lot more to this than just the GVWs.
What's the other?
The number of truck trips, the number of people on site, the number of employees that come to, not just come there to start the day, but are in and out
We
of
meet
their
that.
days.
We meet that standard.
Okay, you say, yeah.
I mean, do we not meet
Maybe.
that standard?
At this point, because you have other employees that you pick up other places, you go other places, and they haven't necessarily shown me that they don't come to the site ever on a day.
think the code
Much like to another point, and this may, that came up earlier about when I asked the question about the wholesale nursery. The answer to my question was that everything was delivered. But no, everything is by Mr. Dobson's trucks. Now, later on in the discussion, it's not all delivered. All of the other landscape people throughout the county come and pick up. And maybe that was just misspeaking, misunderstanding, whatever. But, I came away from an answer of a question with one idea to find out an hour later that, oh no, yes, we do deliver, but also people, there are trucks in and out picking things up as well. And those are the types of things with the employee questions, the trips in and out, what the trucks are used for, that give me concern. Because this does open a very wide door going forward.
So I would have to look back in the video or the transcripts or
Sure,
whatever it is
whatever.
to see exactly the context of that. I don't know if you're saying or misinterpreting.
And I may
thinking
have
that-
misinterpreted.
That
that's
my
all.
trucks are coming back to pick stuff up. I'm saying,
No.
I don't know what
But-
context.
No,
this is in.
I was asking about the
We
wholesale.
deliver
nursery.
and they pick up.
Okay, but at the time to my question, the answer was you delivered. So that's a different. Okay, and I may,
Understood what you were
I
saying.
may be
specifically.
mistaken as well, but these are the types of things that, for me and for my vote, I need to feel comfortable with. All of this whole package.
So
So
Brennan,
here- real
okay,
quick.
go ahead.
So, and I'm not saying which way this is going, so if, say, we got to an approval point, Zach's committed now to a different agreement on the vehicles, but they're operating the business now, so what would the time frame legally, would they have to get down to that compliance?
I think you could constitute that would have to be done immediately, meaning that those vehicles are already out of compliance with the GVWR if the estimate shown in Mr. Heikes' testimony purports with the fact that they are in excess of that 16,000 pound rating limit. I think, the planning commission could obviously require immediately, or if you all found a reasonable time frame that you felt would be suitable for that's something that have to be done immediately because it's already out of compliance with what the code requires for cottage industry use. So it doesn't necessarily need to be a condition of your approval, and I think Zach's noting and acknowledging that here is that the code already requires that. To the extent that it's required, then they have to comply with it. There's no way around that. There's no variance for the availability to exceed that weight rating. That is a quantifiable limit that's placed on a cottage industry use specifically here. So it could, if you gave it an approval by tomorrow, you could say it would have to be in compliance and those trucks could not report to the site.
So Zach, is your commitment that you're saying you guys will meet those standards, or those are the only trucks that he would have, or he would just?
Those would be the only trucks that we would have on the site, or the trucks that we're allowed to have on the site under the code. So that's the commitment.
Is the list that you gave us what's there now, other than the Isuzu that's wrecked?
Yeah.
That's it. There's no other trucks there.
There's the Isuzu that was wrecked, and then there's the nursery truck, and that's it. Correct?
Yeah.
Brennan, back to the wholesale nursery, site plan approval. That would have to come before the planning commission, even though it's a permitted use in regards to,
Well, if it was
Traffic.
operated independently on the properties, separate from another use. I think the code affords in the conservation zoning districts that you could operate a wholesale nursery and it would fall under an agriculturally permitted use, not requiring a site plan. In an instance where a nursery includes components such as office space or additional employees to an extent that we would see fit, we would require a site plan in that instance. I think in this instance, they've included as part of their application because part of that wholesale nursery is being conducted in conjunction with a cottage industry use on the site as well. So that was in an effort to bring full transparency to what they're requesting approval for. But you could, in theory, operate a wholesale nursery on a property without needing a major site plan per se.
Okay. But in this case, it would need site plan approval.
Yes, because it's in conjunction with another ancillary use on the property.
Yeah.
So we've had them include that here. I think really mainly for the point of clarification of vehicles, number of employees and things of that nature. So I think it's necessary and warranted to be included as part of the approval of this application.
So I'm gonna go back to the road. You've got a private road with 25 homes plus this business, potentially a wholesale nursery with wholesale traffic other than the applicant coming and going. That's a no for me on a private road, just on its own. If that came before us, given the fact that it's a private road, I just don't see how we can do it. I just don't see it. This is the worst day of being a planning commission member that I've had in 9 years. I can promise you that.
Yeah.
This is the worst day.
I mean, my thing is, where I'm at is, it's like what I've said before. Even with the legal, I don't, and I know we just have argued the points, but if they're committing to what we as a county have permitted in a cottage industry, like I said, I believe that somehow this is gonna get through, whether it's here or a longer method, but which I'm just concerned and want the county to talk about is like, this is setting a precedent. It's gonna be an issue. I know it's gonna be an issue, no matter what each side says, like, and we have no plan as a county how we're gonna police it adequately. So that's my concern.
I think we do our job and then it goes where it goes.
It goes where it
Yeah.
goes, right, exactly.
Well, then doing our job is looking at the standards that were set for us in the cottage industry and telling the county to hold them to that standard that haven't been held to. And that's where my concern is. I don't think we're gonna hold it. Well, Chip, I'll tell you one thing. I have a feeling that this ain't gonna be your worst day.
I think
this
it
is gonna
is.
come back.
Yeah.
I
Yeah.
know, but I'm saying as far as a business, just like Zach said, we're affecting people's lives here. And this isn't a good day. Not a good day.
I don't feel as bad. I mean, we didn't make the standards and we didn't break the standards.
Yep.
So, I mean,
Yep. I don't see any way to get there.
But to your last point, Mr. Bees, I understand what you're saying, but we're committing to meet the standards. I know there's some skepticism, and I understand that, but I just want to be clear again about what we're asking for. All we're asking for is what is allowed under the code.
I
That
know,
is it.
but
Okay.
I know what's gonna happen. I mean,
So-
we've asked a few times and
Yep.
it's never
Right.
met them, so it's just,
But there's no
there's
way,
nothing I can do
there's
about
no
that.
way employees in trucks that you can't separate those, in my opinion. In other words, all that is coming out of that property as Dobson Lawn and Landscaping. Employees, trucks, the road is an issue.
And I'm saying, what if we get rid of the truck for the nursery, and our nursery employee, we're still under what's allowable? We're still under.
Okay, so you got 5 trucks, but that's still including some of those pickups that
But again,
the families, in other words, the whole thing is the business truck. So any truck that's in my view, that is titled under Dobson Lawn and Landscape, or even the
Even just
boys
used.
using the vehicles. It's the whole
So
thing.
Timmy's truck, you're saying, if he goes and picks up his daughter from
No,
daycare
no,
and
I'm
brings
not
her home?
saying that. I'm saying that they're used for business. Those trucks aren't coming and going at 6:30 in the morning, going in and coming out for well, I'm not getting it. I'm not
Yeah.
gonna speculate.
No,
what
they're-
they're doing. Yeah, I get it. Yeah. Yeah.
I've said all I need to say.
Okay. Yeah, I mean, any further comment from the public here? Do we want to take a swing at a motion?
I just have to go back to the original. So it's a major site, and did it have tied to it, cause it's, on our notes, it doesn't, for this month, it doesn't have it. Do we have, is there, are the landscape waivers and stuff tied to that, or we just, is it just the
Yes, it's a landscape waiver, and I think there's one more.
bicycle and
Yes.
side lights?
Yes. Sidewalks and streetlights and landscaping. Just to accept the alternate landscaping plan. He has provided a landscaping plan, it's just not as, it's not completely consistent with the code, but it meets the definition.
Okay. I'll take a shot at it. I move the planning commission approve major site plan for Dobson Lawn and Landscaping and Timothy Dobson Jr. to operate the cottage industry and greenhouse plant nursery, subject to the conditions of approval.
Which are?
The applicant shall comply with and address all TAC comments from the November 12th, 2025 meeting and return to TAC with a plan that addresses those comments.
Do we want to make mention of the vehicles?
Trucks.
And with the applicant agreeing that they would remove certain vehicles to meet the requirements of the current cottage industry standards.
Does that include the wholesale landscaping, nursery, or greenhouse and nursery? Are those vehicles included into the cottage industry as well as the number of employees? Is it all tied together? Along
Me
with the
personally, I
truck-
don't know
truck
how,
trips?
I mean, I don't know how we regulate he's legally allowed to operate wholesale nursery.
Right.
Not without site plan approval.
I mean, I think that's so,
I'm asking.
yeah.
I mean, is it all the same?
I'll leave my motion as is, just with
Okay.
the
That's
staff.
fine. Yep. Okay.
Does the wholesale nursery employees count towards the cottage industry employees?
You're asking me?
Brian?
I think under the code provision, a wholesale nursery doesn't have a limitation
Agreed.
on number of employees that you have. If you all want to offer a condition outside of that, I think it's, I mean, you can speak with Andy, but I think it's within your purview
Well,
to.
I do,
It
mean,
is within your
we can
purview.
vote on, but I mean, my recommendation for him would for legally is to get the truck and the employees separately.
So I think you should probably clarify and include in the condition that any trucks or any employees associated with the nursery business be included under or separated out in some form or fashion, because that's not something that we discuss in our conditions. But if you all think that that would create some comfortability, or you in your motion, that would create some comfortability for you, I think the separation from Dobson Lawn and Landscape for the vehicles used specifically for the wholesale nursery is something that you could.
I mean, I can make
Required.
I don't think legally I'm allowed to do that, but, I mean,
I think you are.
I think you are. I
Yeah,
mean,
you are. Under 190-60, just the whole site plan approval process.
Well, then, one of the conditions would be to have the employees and the vehicle associated with the wholesale nursery be shown under a separate legal entity.
And I guess, just as a purpose of clarification, did you want to include a timeline of compliance related to the vehicles associated with the cottage industry use, since we do have vehicles, I guess, at this point that we have undetermined weights for?
My compliance timeline would be immediate on actual usage, and then, based on, working towards either eliminating those vehicles or not, but immediate compliance on actual operation and use.
You'd have to give him 60 days, because if those trucks were retitled, they'd have to be re-inspected and blah, blah, blah.
So within 60 days, is that the general?
Don't you think, Timmy, it takes 60 days to get them re-tagged and titled?
I believe so.
Solved.
All right.
Not gonna get a second.
No.
I can't second.
You can second.
I can second?
Yes.
I'll second it. So we have a motion by Commissioner Spies, a second by Commissioner Corson. If there's any further comment, we'll call for the vote. Commissioner Spies?
Aye.
Commissioner Council?
No.
Commissioner Stranahan?
No.
And I vote aye.
So the motion fails.
At a 2-2. It does. So. Moving on.
Thank you.
Thanks, Zach. New business, Talbot County Planning and Zoning.
Can I make a motion to go into executive session? I have a question about that.
Yeah.
Yeah, I think you can make that motion at any point in time in the meeting if you want to go.
I'll
into-
second
I'd like to
that.
make motion to go into executive session. Second.
For legal
Legal
advice.
on something. Yep.
Motion by Commissioner Council, second by Commissioner Stranahan. You got me?
Maybe,
Yep, I think we're on. I think everything's going, so I think we are good to go.
Okay.
Sorry, can we make a motion to
yep.
come back into open session? Sorry.
I'd like to offer a motion that we go back into open session.
second.
Motion by Commissioner Council, second by Commissioner Stranahan to go back into session after seeking legal counsel. Call for a vote. Commissioner Hikus.
Aye.
Commissioner Stranahan.
Aye.
Commissioner Spies.
Aye.
Commissioner Council.
Aye.
I vote aye as
So I
well.
would say that Mr. Hikus probably should have abstained from that.
I can, yeah.
Okay, but let the record reflect. First item of new business, Talbot County Planning and Zoning Commission review of the Talbot County, Maryland Department of Planning 2025 annual report. Brennan.
Yeah, so each year, Maryland Department of Planning requires every jurisdiction to do a annual calendar report of the number of new residential development units or new residential building permits that have been issued, rather. In our case, and in many cases, we've been required to report the short form version of this. The long form version obviously is a much more intensive application that you have to submit to the state, and that's required anytime you have more than 50 new residential dwelling units. I think probably for the past 6 or so years, we've fallen under this short form status because we've been anywhere between 30 and 50 new homes. In this instance, you can see in the document provided for the memorandum, we've had 16 new homes that have been constructed or permitted in priority funding areas and 33 in non-PFA areas for a total of 49. So we fall just within the limitation of that short form reporting period. And I think so, generally speaking, every year when we've done this format, it requires the Planning Commission to take action and approve this report to be sent up and forwarded to MDP. Likewise, we'll be taking this report and providing it to the County Council as well. But we're essentially here asking and requesting you all for an approval of this report so we can send it to MDP for their reporting metrics. They use this data along with the other counties' datas to show their growth projections and other types of resources that they model and information that they send out on an annual basis from the state as well.
Okay.
And I would highlight that we did note under number 6 here that talks about identifying or implementing recommendations related to the following planning topics. We did check yes in that, and we included bike and pedestrian planning as well as aging population. That's due to the fact that the council established and appointed a bike and pedestrian advisory committee in the past year, as well as a senior citizens task force, which is the reason why we included those topics of interest specifically. As you all know, we're working through the comprehensive plan. The checks on this report aren't really germane to what we're working through in the comprehensive plan, although these topics have come up. They're mainly related to topics or trajectories that the county has invested time or efforts into addressing beyond what's included in comprehensive updates.
Good.
All right.
You need any kind of motion, or are you good?
Just a motion to approve and send up to MDP.
So moved.
Second.
So moved.
Ready to vote?
Oh, motion by Commissioner Council, second by Commissioner Stranahan. Call for the vote. Commissioner Spies.
Aye.
Commissioner Council.
Aye.
Commissioner Stranahan.
Aye.
Commissioner Hikus.
Aye.
I vote aye as well.
Thank you.
Next order of business is Talbot County recommendation to County Council for a proposed text amendment to Chapter 190-61 and 190-62 concerning developer agreements and waivers. Elisa.
Thank you. The file number is text 9, and the purpose of the text amendment is to provide a process with a waiver for surety guarantees for improvements associated with developer agreements for nonprofit entities. And staff is here to answer any questions that you have.
So how did this come about? Can you give us a little background here on this?
A council member was approached by the Bellevue Passage Museum, and we are asking the museum to enter into a developer agreement because they are adding sidewalks and connection to a Bellevue landing.
Mm-hmm.
And so along with the developer agreement is generally a surety, and that's cash, letter of credit. And so the council member brought forth the text amendment to allow for the exemption, or the waiver, sorry.
So if you recall, the project for Bellevue Passage Museum included the walk path from the parking area that's currently at Bellevue Landing,
Right.
as well as resurfacing of the basketball court and improvement to include a bus pull-off for field trips that may routinely visit that site as well. The applicant has obviously experienced, I guess, most of the project is grant funded through federal grants that they were able to obtain. I think based on the level of construction costs for the project itself, the concern there is financing issues with being able to bring the project to fruition, and then also duly having to post the surety for the additional improvements that they proffered as well. Those improvements are covered under a memorandum of understanding with the county already that they've entered into. However, the code under the developer agreement section does require currently that a surety also be posted in conjunction with said improvements. Typically with other projects we see, we don't call them developer agreements. We usually just have landscape sureties because most site plans typically only require landscaping improvements. To the extent that there's paving requirements for ADA spaces, those are obviously federally mandated. So we don't often require developer agreements for things like that because they are a requirement of general compliance. But in this case, this is a little more unique and a project that you all probably are less familiar with because they're also proffering public amenities to be included in conjunction with part of this project.
I'm good. My question is, why does it need to be upon recommendation of the planning commission? Why is it not something that you could approve unless there was an outlier and then you could bring it to us? Like this one at Bellevue, I mean, I don't see why they would need to wait a month to get in front of us or something like that.
So I think the thought process is that this would be ruled on in conjunction with a site plan application. So the waiver would be contemplated similarly to other waivers that are granted or requested as part of a major site plan would be granted by you all in that facet. So anytime there's a waiver request of a requirement, even at a minor site plan application level, if it's of a large enough magnitude, it automatically makes that project a major site plan because they're not complying with that section of the code. So those waivers in that site plan automatically get kicked up to you for approval or recommendation of approval. So I think the thought process was keeping the waiver application process the same in this instance if they were going to be requesting it.
I'm fine with it if there was no other, like if you could approve a site plan and then they just had to come to us for this surety waiver, I think that's unnecessary. But if it's part of something that's already coming to us, I get it. But I mean.
Yeah, so typically there wouldn't be a developer agreement, and unfortunately this was something that we kind of caught at the tail end of the major site plan project for this, since again, this is kind of a newer project that is on county property. It's going to be done by a private developer, so it's got additional things to consider. But in a perfect world, if a nonprofit were to propose development of a project and say they were required to construct a sidewalk, they would, one, request the waiver of the sidewalk, or if you all told them the sidewalk needed to be constructed, they could then petition you all at the major site plan application phase for a waiver of the surety requirement for that sidewalk, complying with the fact that it would also be built because it's a component of the site plan approval. So it would still have to be built regardless because it's part of or in conjunction with the site plan, but they just wouldn't be required to post the surety for it as well.
Okay.
And if they decide not to build it, because if they can't afford the surety, they
We
may
wouldn't
not be
issue
able.
them the occupancy for
Okay.
the site to
Okay.
conduct whatever business or whatever the
Right.
component of the site plan
Site-
approval
right.
was until all of those components were constructed. So the county would still have leverage
Sure.
in those instances to ensure that is the case. And again, I think this is limited to the nonprofit sector of
Yes.
things, understanding that, a lot of nonprofits use grant funding initiatives to construct their projects. I think this council member's concern is that if there's a limited viable amount of money to construct a project and it's ultimately gonna be for the public good, we wanna help them out
Sure.
where we can. So, but this wouldn't apply to a private developer. So if somebody came in to put a commercial retail space up that's not a bona fide nonprofit, then they would have to post that money for the developer agreement regardless. It doesn't apply.
As long as it's not an automatic.
Yes, yeah, that's,
That's
No, again,
That's
it's
not-
it's a waiver. They have to at least meet one or more of the conditions under the waiver components of the code as it cites here, and then you all ultimately would have to review and approve that
Yeah.
as well.
I'd offer a motion for a favorable recommendation to the county council for a proposed text amendment to the developer agreements and waivers.
I apologize to cut you off here, Mr. Council.
sorry.
Really quick, there is one other addition that staff is asking for today. There was an error in drafting. On the staff report, if you look at number 5 in blue, it mentions section 190.62 twice. The one that is in red should read 61.2. It should refer to itself. So we're also, as staff, asking that you amend the language just to include that second reference to 190.62 to be changed to 190.61.2 in your motion.
Friendly amendment with corrections.
Thank you.
Thank you. Thanks, Bryce.
I'll second it.
We have a motion by Commissioner Council, a second by Commissioner Stranahan. We'll call for the vote. Commissioner Hikas?
Aye.
Commissioner Stranahan?
Aye.
Commissioner Council?
Aye.
Commissioner Spies? I vote aye as well. That concludes our new business. We have any discussion items?
No items for discussion at this point in time.
Staff matters.
So most recently, we're actually, I know we've brought Julia a couple times to planning commission meetings. She's been our intern that's continued through an internship program that we've partnered with Salisbury with. We've actually had the opportunity to extend her internship all the way through the end of May of this year, which is wonderful. So we'll be sending her off back to school for her final year to hopefully graduate and maybe seek employment in this same type of local government atmosphere that she's been exposed to. So we're hoping that that program can continue. Most recently, we've been contacted by Salisbury University to continue this internship program with them because they've seen great success with their students working within our department, which we're greatly appreciative of. And I'm happy to say that we'll be hopefully onboarding a new Salisbury intern to continue participation in this program that they have, hopefully by June timeframe. So we'll hopefully have a chance to schedule and bring them to a future meeting with you all and introduce them, and they'll be working closely with us on all matters planning related, but most importantly, the update to the comprehensive plan. So it'll be a great opportunity to continue another local partnership and get exposure for young professionals around the area into local government and what it means to be a government employee.
Great stuff. Work sessions.
So we're currently working on some data requests right now for the comprehensive plan update with Wallace Montgomery. We've gotten a lot of information back to them already to finalize some of the chapters that you all have already reviewed. Currently, we have a data request still outstanding, trying to get some more information from the Public Works Department so we can finalize some of the more quantifiable calculations that are required to go into the land use element. So we're hopeful we can get that information back to them soon so we can kick that chapter off here in May. I will say if we don't have that information available to you, I think we're going to intend to hopefully have a couple of finalized chapters for your final look that we've already looked at so that we're at least continuing to move forward and get some of these chapters wrapped up and finished so we can do the final cut draft of them, include some imagery and a little bit more formatting to kind of get that final product ready to go so we can get it up to the county council. But right now, in the drafting phase, the only sections we really have left that you all haven't taken a peek at are really our real hefty sections, which are the land use element, which is going to include components of the community design and appearance chapter, which was a standalone chapter in the previous comprehensive plan. And then we also have the water resources element, which we'll be inviting the Public Works Advisory Board in to review that chapter with you all as well. Likewise, we'll probably have the opportunity to invite them to discuss the land use chapter because that kind of, it doesn't coincide with the water resources chapter, but they very closely touch one another based on development and capacity analysis and things like that.
Great.
So do you feel like we're still on time, or are we drifting behind?
Admittedly, I think we're a little behind schedule right now. Unfortunately, this past month we were notified the project lead, Michael Bayer, that was working with us from Wallace Montgomery. Well, unfortunate for us, but good for him. He moved on actually to a position, I think he's working in the town of Bel Air now. He is the planning director for the town of Bel Air now, so he accepted a position back in local government. So we're working not with an entirely new project team, but with a new project lead from Wallace Montgomery, getting them up to speed on some of the deliverables that we have, which kind of resulted in a little bit of delay this last month. So it didn't more or less put us a month behind, but it certainly kind of threw the schedule off a little bit. So
we're
drove
hopeful
him
we
off
can
the
still keep.
ledge.
What's that?
We drove him off the ledge.
Well, I think, he previously worked in local government prior to accepting the position at Wallace Montgomery. I don't know if that was just kind of a, mutual agreement, or if that was something that was kind of leading him to greener pastures and he wanted to be back in the local government sector of things. Certainly understand it, but, I think the project team that we have now, they're on top of the things that we have. Bryce and I have had 2 debrief meetings with them, and just let them know all the things we have outstanding that we need to get on top of. So I'm hopeful we'll get that done. I do anticipate maybe a little bit of delay, and we'll probably bump up in some timelines because we do have to send the plan up to MDP for their 60-day review, and then get their comments back so you all can kind of digest those and figure out how we want to respond to them prior to, putting you all in a comfortable situation where you could ultimately forward something to the county council. So there may be some delay there. If it delays to the point where this council, city council can no longer take action on it, I think we may just have to pivot from that point and continue on with the plan and see if the future council wishes to, kind of table it and do a little more public outreach, or whether or not they want to have some included work sessions with you all. But we'll do our best to coordinate those efforts if it comes to that. So.
All right. Commission matters?
Unless you all have anything for yourselves? We don't have anything
Move
for
to
you?
adjourn.
So moved.